the plan. You've chosen with outside. I just wondered if you could just talk about how they are going to be developed outside the plan, and what sort of input, if you like, concerns citizens might have a go at.
So I understand that, as I've said in my report, they will be developed post decisions, if they aren't already being developed. I imagine there would be some input from practitioners of some description. I'm not sure exactly what that will look like. I can certainly talk to officers around what the intent. I don't believe it'll be a full-scale public consultation like you would expect for a district plan, for example, and that would be the risk with putting them into the district plan at this stage, at the submissions stage. Post notification does limit the input of members of the public. But I can come back to you with a fuller response and reply on that matter.
Yeah, that would be helpful, just because I'm conscious there are a couple of submitters that were interested in them, and especially interested in them sitting within the plan, but I understand they're not at a point to allow that to happen, but providing them some comfort of the process afterwards might be helpful. Yeah, thank you.
Ms. Pascal, just a follow-up question to that. My understanding is that for the MRZ and the HRZ, where standards are met and there's no consent, then therefore there's no urban design guidance required, and that's intentional. It's only where a standard's not met, or where there's 4 or more units proposed, that I think a restricted discretionary activity is required in both zones, well, certainly in the MRZ anyway, or exceeds 22 metres in the HRZ. And then we trigger certain policies, and I think the policies 12, 13, 14. Yeah. And so those policies would provide presumably along with any matters of discretion, the input to consider urban design matters in the round.
At this stage?
Yes.
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 Okay.
So yes, those policies, submissions on those will provide useful guidance as to where those design guides should, what should be within the design guides, yes, and also my recommendations if the panel were to accept those. The question around where the standards are met, and whether it's useful to still have some guidance so that applicants can understand how they could meet those standards. Yes. I think that's one that's perhaps outstanding.
Yeah. Can you remind me, do the matters of discretion where standards are not met refer back to those key policies that touch on urban design?
Yes, they do.
Okay. Yep. Okay. And just to complete that, that's pretty much the same approach for the commercial and mixed zones that we heard about in Herring Stream 2, isn't it?
Yes, my understanding is the council's taken a consistent approach, yes, across the zones.
Yes. And just for the final element of the trifecta, the LLRZ zones, the large lot residential zone, that's how would you describe that? It's urban design plays less of a part in those zones, doesn't it?
That's correct. There's a policy or possibly an objective around planned character, yeah, and amenity, and that's the critical one, I suppose, in terms of design outcomes. But given the lower density anticipated there, yes, it's not seen as necessary to have specific urban design, yes, requirements.
And this was an intentional strategy that was developed through the Section 32 process?
Yes, that's my understanding.
Okay, thank you.
Yeah, one more from me on urban design as well. Do you know that whether council is actually committed to preparing this urban design guidance, or is that going to be looked at in the future? Because it could be, once you have an operative plan, it would be quite useful if straight away there was urban design guidance, because there seems to be some reliance on the non-statutory urban design guidance to give effect to the plan. But from what you're saying, it might be developed over time once there's a whole bunch of resource consents in and looking at how the bulk and location and the implementation of those policies, the urban design policies. Do you have any feeling for when that might occur, or should that be a question for potentially Mr. Gerd?
I don't know the exact timing of that development of that guidance, but I do know from officers, certainly through the development of the plan itself, that there is a commitment to developing it. I can confer with Mr. Gerd now.
Yeah,
if you
well,
like.
that would be useful, because it's a recurring theme. And certainly myself and the two commissions to our right, we were involved with the Wellington City District Planning hearings as well, and the whole issue of what the good design guidance looks like inside and outside of the plan, and quite a lot of effort was put into preparing design guidance which was fit for purpose in that context. Yeah.
So Mr. Gerd has advised that there is a decision from council that the guidance would be developed. However, there isn't a commitment to funding of it at this stage, and the drafting of that guidance hasn't yet started.
Okay, thank you. We should move on. Statutory and policy context. National direction instruments.
Aside from the new National Environmental Standard for detached minor residential and the electric charging one, the MPSs that were gazetted in mid-January of this year, the infrastructure, natural hazards, and the changes to IB and HPL, etc. Have you had taken any cognizance of those in your 42A or your rebuttal?
Not to a degree of detail that I felt influenced the outcome or the submissions that were received. I suppose I saw those ones as being less relevant to this topic.
Yes.
Yeah.
Do they, in terms of the zoning requests, where there are some limitations on a site that might involve infrastructure or hazard, whether that's flooding or something else, are those two new MPSs of relevance?
The NPS infrastructure may be. I don't know that natural hazards is, given there are overlays in the PDP to manage that issue.
Right.
And hazards wasn't a factor that I considered in those rezoning requests because of those overlays being in place.
Okay, so you've, and this isn't a trick question, you've assumed that the overlays are accurate and that they're fit for purpose, and so you haven't gone back to revisit a higher order document above those?
No.
Okay. We might follow that up in relation to some of the zoning matters in it. I'll have a similar question for Mr. Horrell in relation to the MPS HPL on some of the rural rezonings too.
But the thrust is that plan change 56 to implement the MPSUD 3 and 4 has largely been rolled over in terms of the approach to the objectives, policies, rules in the district plan. It's not new then, to a large extent.
That's correct. And I would also note that many of those hazard overlays were also introduced as part of that plan change. They're not actually new in terms of the PDP.
Just the language in the MPS NH is quite different. One of the key phrases that comes through in the MPS NH is taking a proportional approach to development, whether that's zoning or as a consideration on a resource consent. So, which is quite a paradigm shift from the previous approach of taking a precautionary approach, particularly where information was uncertain. So, look, there's no question there. I just wanted to get that recorded, and we may revisit that again later.
Okay, we'll move on. National Direction Instruments. Right, section 3. Section 4, key resource management issues and contention. Then we're into the strategic directions.
Just in terms of the USSD 03, actual paragraph 53, you just talk about the RPS appeal, and I just wondered if you had any further updates since you'd written that.
No, I haven't got any further
Yeah.
updates.
Thank you. Sometimes they move fast and sometimes they move slow. And then just further to that, at your paragraph 59, I just wondered if, I think there's a typo there. I think instead of 05, did you mean 03? Because then in the next
Yes.
paragraph, you talk about 05. Yeah,
Yes,
yeah, thank
that
you.
is a typo.
Yeah, thanks.
Apologies.
No problem.
But what you're saying in relation to the RPS and plan change 1 is that it's broadly consistent, the approach that Hutt City is taking in relation to urban form, urban development.
Correct.
Okay. Then on to objectives. Just a clarification, new objectives sought, paragraph 71, where the regional council seeks a new objective. The regional council have chosen not to appear in support of this. And the reason for not wanting to accept that new objective is that it's uncertain or does not really fit in with that. I wasn't quite sure why, what the main reason was.
Some of the issues or the matters that are within that suggested objective I considered were more appropriately addressed through other regulatory mechanisms such as the Building Act. So structures is Building Act. There are also other parts of the district plan, or the proposed district plan rather, that I consider would address the matters like infrastructure and stormwater and those kinds of things that seemed unnecessary. And I believe in the regional council's tabled statement, they've accepted that response.
Yes, the whole interface with the RPS is interesting, particularly at this particular point in time. And the GWRC did write a fairly comprehensive submission, but we haven't seen them in any of the 3 hearings to date, so we'll see where we get to. All right, moving on. I'm at 4.302, 4.3.2, para 79. Objective 04.
Just had a question on that one. So just in terms of Mr. Ross and Mr. Rumsey's submission about building heights and, you know, the effect on neighbouring properties. So the way loss of light is managed is if a development does not meet permitted activity standards, for example, height in relation to boundary, how would the design guides assist with that?
Well, I think just thinking theoretically here, since we don't actually have design guides to speak to, that would be, I guess, guidance around different ways of site layout and maximising access to daylight or sunlight as far as practical, given certain site constraints and those kinds of matters. Notwithstanding that there is some caution needed around how restrictive that could be in terms of any assessment or conditions of consent, given the MDRS requirements to provide for building heights of, or in the high density residential zone, it's 6 or more. So, yeah.
Okay, I'm at para 89. New objective sought. Okay. And then we're into the policies. P2, P3, P4, P6, P7, P8, P9. Then waste management. One, two, two. Okay. Right. And we're at policy 12 now. I think 1, 2, 4.
I just wondered, you've suggested to delete, policy 12, to delete clause 2 relating to daylight. And I just wondered whether was there to be a consequential amendment to standard 2 to 5 as a matter of discretion to refer to the correct numbering of that policy.
Yes, there will need to be a consequential amendment. Yeah, I can show that through my reply.
Yeah, thank you.
So we're up to, I'm at about para 129. All the way through. Into policy P14. MRZ and HRZ. Then into the assessment. P3, P4, P6, P7, P8, P9, then new policies sought. Design guidance. Waste management.
Pascal, this, the submission by Enviro NZ is one that you've revisited in your rebuttal, and you'd originally, I think, recommended not making any amendments, so rejecting the submission. You've now changed your position where now proposing some policy amendments for waste management provisions for multi-units, developments greater than 4 units. And not less than, not 1 to 3. And that's, the reason for that, as I understand it, is that the 1 to 3 is mandated by the MDRS. You can't make those provisions any more restrictive without good reason, qualifying matters. And so is that the rationale for that approach?
That's correct, yeah.
Yes.
Yeah.
And just to confirm, the change that you're making is just to the policy provision. It's not to the rules or standards themselves, is it?
That's correct, just at the policy level.
Yes. So when there's 4 or more units, that's a matter of it'll be a matter of consideration. There's no, you're not proposing any detailed metrics or standards in relation to the dimensions of set down areas or anything like that. That can be covered through the bylaw, presumably.
That's correct, although I do note the bylaw does only apply for 10 or more units.
Okay. Yeah.
So my other recommendation was that the design guidance provide some more
Okay.
help to applicants around how they could achieve that outcome in the policy.
Yes.
I was concerned with putting in detailed metrics that are inflexible
Yeah.
as standards or rules.
Yeah. So for 4 or more now, that's a live issue as part of a restricted discretionary activity, and presumably the response to those resource consents will have the ability to put in detailed conditions about waste management collection.
Yes.
Okay. I will be interested to see what Enviro NZ make of that.
Yeah.
Yeah. Thank you.
It certainly is an issue though, for 1 to 3. And, you know, how the waste collection truck is actually going to get in there. But presumably a good architect will be thinking about that anyway. It's an observation, not a question.
Yeah, and as a resident in a multi-unit complex of 17 units, I certainly know the issue. Wellington City actually have a different approach altogether, and are currently not making provision for collection areas for multi-units. So.
All right, we're into the assessment of P12, HRZ and MRZ P12 and HRZ P13.
Yes, just in relation to P12 again, and specifically to do with Laura Skilton's submission. And I just wondered what your thoughts were as to the effectiveness of the plan to manage shading effects on neighbouring properties.
plan does include the height in relation to boundary standards, so one for the medium, one for 1 to 3 units, and then another standard for 4 or more. And that's quite a comprehensive standard from memory. And there's also the setback requirements as well. So I think there's a number of things that work in combination to try and address shading impacts. But at the same time, the PDP acknowledges that these are zones where over time more development will happen, and therefore the amenity that we have now is going to change, and that may include shading effects. And for those situations of 4 or more units, that's something that would be assessed through that consent process. And obviously for your up to 1 to 3, it's compliance with the standard. So yeah, I think the plan deals with it to the extent that it can within the constraints of things like the MDRS and NPSUD.
I noticed Ms Moore commented that access to daylight could be a matter of discretion should a side yard boundary be infringed. Did you turn your mind to that any further?
Probably not in detail. I think that's possibly something that I could consider that further, yes. Happy to do so through reply. Potentially missed that particular nuance.
Thank you.
Okay, I'm at para 181. Yep. Just in terms of your paragraph 184, when you're talking about Kāinga is seeking deletion of the matter about usable open space. So just to paraphrase what I think your intent is, so the intent is that in terms of site design, that where the open space is and what the function of that is actually more important than a pure metrics-based approach. Is that, and perhaps Ms Moore might be able to comment on that as well. Needs to be usable, use be purpose. If it's a little strip somewhere, it doesn't have much utility. It's more about getting the usability and the functionality of the open space.
Yes, that's my understanding, but I think Ms Moore's probably better qualified to respond, so I'll defer to
Yes. Thank you, Ms Moore.
Kia ora. Yes, essentially that's correct. And that is a policy that's often what you would kind of see in an urban design guide that is explained quite clearly. Obviously, in this circumstance, that's not the approach they've taken. So, yeah, in terms of just, it contributes to positive site layout. Obviously, you're not going to get use of everything that happens, but oftentimes in these sort of development processes, the placement of the building is sort of considered first and foremost rather than how the function's going to work in between these spaces when you're going into multi-unit site design. So just phrasing that in a way that is purposeful, I thought would assist in making that clear in a policy framework that doesn't have a statutory design guide behind it.
Mm-hmm. I think the first thing that a lot of developers will be looking at is maximising yield first and then seeing what how they can fit expectations for yield into the site within the restrictions that there are. That'd be a fair comment.
In my experience, that is true.
Okay. Para 185. I'm at paragraph 190, and there's a sentence right in the middle of that reasonably long paragraph saying the matter of sunlight is something urban design professionals are familiar with assessing, and there is supporting guidance within the profession about how this should be measured. What is the supporting guidance?
I can take this one. So with the establishment of the new Urban Design Institute of Aotearoa, there is a practice note on assessing sunlight.
Yeah.
So it's probably similar to what landscape architects use in that it has a sort of moderate, less than moderate impact, quite a detailed assessment of how that sunlight can be assessed. And it relates kind of to the outside of a building and how it touches the building, but does not extend into the building itself.
So it goes a lot further than what I call Mr. Hudson Moody approach to determining sunlight. If you know what I mean by that.
No, not quite. The reference
Oh,
going over
okay,
my head,
so-
but
so he having been involved in a lot of hearings where sunlight is an issue. Mr. Hudson Moody from Spencer Homes has developed software which gets used very frequently to be able to determine the extent of sunlight penetration depending on the time of year as well, and putting in the three-dimensional thing. So that will give you the graphics. At certain times of the day and at certain times of the year, this is what the impact is going to be of a structure of a certain size. Yours is more, the Urban Design Institute approach is more a qualitative assessment of that rather than a pure numbers game.
it is a mix of both. It does come with those numbers, so it will look at those different times of day across the year, but also adds that qualitative assessment of what sort of space it is, if it's public, if it's a private outdoor living, and lets you as a whole sort of decide on what sort of impact that's going to be and on a scale.
Yes, and those of us who live in the Wellington region, and particularly at this time of year, having the solstice yesterday, recognise how valuable getting good levels of sunlight into properties is. And again, that's just an observation.
Just to follow up, Ms. Moore, the UDIN's practice note, is that quite recent, is it?
Yes, it's beginning of this year, I believe. And as of now, I think there are about 27 registered urban designers, and we've all been briefed
Okay.
on how to apply that. So at the moment, registered urban designers are being hired by architects and such to, when it's a matter of discretion in terms of it, seeking consent, this is the sort of way forward of assessing those matters.
Right. And are you saying that it has similar status to the Institute of Architects practice note on assessing character and visual impact, and in terms of the symmetry between minor, lesser minor, and moderate, low, etc.? Does it use that sort of approach?
Yeah, I'm not familiar with the architects one myself, but I know the one that the landscape architects use.
Yeah,
and
sorry,
it's- yeah.
I meant the
Oh,
landscape.
yeah, yes, yeah, it is. It follows that
Yes.
assessment, the level of effects, yeah.
And so has it been, have the courts recognised that document?
I am not sure about that, but I know that the UDAA is sort of, was made to provide more weighting for registered urban designers in
Good.
a hearing situation. yes.
Sure. Okay. Where would we find that document?
I am not sure if it's online. The approach is still being established of if these are shared beyond the institute. I think there are two practice notes. One of them is widely available for everyone who needs to understand it, and
Yes.
then the assessment tool and how it's used, I believe, might be exclusive and internal to
Okay.
the institute itself.
Thank you. Maybe you could just assist in the reply for Ms. Pascal, just to give us some information on that.
Yeah, I can do that. Thank you. It's new, so I'm still learning these things myself.
Okay, so on MRZ P13 and you recommend a change to that particular policy. But when I was having a look at that and I had a read of the whole thing, number C says improves outlooks from dwellings and softens hard-built surfaces. Is there a sort of a lay person's interpretation about how providing on-site landscaping can improve outlooks from dwellings? How does this work in practice? Because the outlook is presumably fixed from a dwelling. Or is it you're going to put some tree in the way or a sort of a landscaped area in the way? How's that interpreted?
Might defer to Ms Moore for this.
Yeah, no, I know, and there's no submissions on it. It just sort of jumped out at me about how, if you were going to be looking at the impact of landscaping, how would you seek to say something is going to improve the outlook from dwelling versus something which is not going to improve the outlook from dwellings?
In my experience, quite typically you'll get a design of a multi-unit development where rather than terracing the houses, they sort of put 1 metre between each of them to be able to sell them as a freehold house, which is quite attractive in this market. And in those circumstances, the landscaping requirement is met by putting pebbles down a side yard with a 1.8 metre fence outside. So I think what this policy does is try to look at the purpose for the landscaping requirement, not just having this arbitrary measurement that it will somehow make it beautiful, but actually looking at what those things are trying to do. And when you're getting these more sort of intensive developments, ideally actually trying to avoid doing that approach, which goes back to that meaningful spaces policy we're talking about and how those can contribute to a more attractive site layout. But if you were going for this approach, how these sort of designs might actually improve to enhancing the amenity of those living on site and also those for the public realm.
Okay. Moving on. And para 197. At 198, almost the last half of that paragraph, you say Ms Moore notes that the benefit of requiring assessment design treatment such as modulation and variation is that it seeks to enhance the urban environment and ultimately improves the amenity of the public realm, particularly in the case of large proposals of 4 or more residential units. So and flicking it back to that policy, it's about both amenity and character outcomes which are trying to be achieved? Because aren't they two different things? One is amenity for those who are on site, whereas character is from those who are potentially looking at it from a public view of the site.
Sorry, I'm not, could you just repeat the question?
Because the question is, it says that the benefit of requiring assessment of design treatments such as modulations, etc., has it tries to do 2 things. One is in relation to the overall amenity of those who are living on the site, and the other part of it is trying to make it look nice from those who are going to look at it from beyond the site. But aren't they 2 different things? Or can they be just all treated together?
I actually read this, or my understanding here was that it's the amenity of the public realm rather than just for internal on-site amenity. That's how I had understood it, but Ms Moore might have come at this from a different perspective?
I would say that amenity applies to both. I think in terms of trying to get the best outcomes from a district plan, as an urban designer, I do prioritise what is happening to the public realm, because that's the thing that we can control. The public and a private market people will live in the houses they want to live in, the example I gave before, in terms of that outlook. Those are sometimes those things that people are willing to compromise on. So I do prioritise amenity as it is to the streetscape. And I think in regards to your previous question about character, and that is a different thing. Amenity can contribute to that, and dependent on the zone and if there's any character.
So the district plan shouldn't go anywhere near dictating what rooms are used for, what the outlook is, what it's actually going to be like to actually live on a property. It's mainly about the public realm,
I'd say
the external factors.
public
rather
realm is the priority. However, there's definitely benefit, I think, in encouraging developers to consider the amenity of people living there, because we're building these houses for the future and they should be livable. But in terms of what the district plan can control, or where it should place its priority, that's how I sort of rank it.
All right. Okay. Right, just moving through 443 recommendations. Then we're into the rules. Then we're into the standards. 297. Not as yet. Okay. Well, I'm at 290 now. I didn't have anything in front of it. Waste management again, David.
297 is go.
Oh, 297.
Yeah. Got a couple of questions there. Well, a couple of observations for both you, Ms. Pascal, but also for the rural authors. I note that you've, in relation to Go Architecture, you've recommended accepting the submission, which is to increase the gross floor area for minor residential units from 60 to 70, which would bring it into line with the new standard. I think that's the rationale. Yes. I noticed in the rural report there was a request to change a similar metric from 80 down to 70, and it might have been for minor dwellings. And Mr. Horrell, if you could just explain the difference between that situation and this, because I think that request was recommended for rejection. So at the time, if you could just take a note and tell us why the two are different. So could you repeat it's paragraph 297, where in the residential zone, to give effect to the National Environment Standard for detached minor residential units, the recommendation is to increase the floor area from 60 to 70 to give effect to the Go Architecture. I noticed in reading the rural report, there was a request to change the metric for minor dwellings in the rural zone.
Yes.
From 80 down to 70, and that was recommended for rejection.
That's right. I guess in the rural zone, the minimum was 80, so it was actually the opposite. It was larger. The minimum can be more enabling than the NES.
Okay, but can't be more restrictive.
We felt that it was appropriate to enable a slightly larger
Okay,
minor residential dwelling in the
Okay.
rural zone.
right. We might come to that in the rural zone, but I just wanted to understand the rationale for that. And secondly, Ms. Pascal, in recommending a rejection of the submission by Ron Biernink and Glenda McCullum in that second part of paragraph 297 at the bottom of 81, and they wanted the HRZ standard to be more directive and say that development cannot occur where Three Waters infrastructure is not available. You've said consideration of infrastructure capacity is addressed during the consenting stages, and this allows an assessment on a case-by-case basis, noting that site-specific solutions can be adopted and applied to address servicing constraints. That's not necessarily what you say in relation to some of those other zoning requests, and I'm thinking particularly of the Silverstream submission, where water supply and capacity is, I think, the only reason now for not recommending that the entire zone be rezoned. I don't want to ask you about the Silverstream matter now, but I just want you to reflect on that, because it just seemed that there was a disparity there in what you were saying there, and also a slight disparity in one of the other zonings where you've said that water constraints can be dealt with and you've recommended the zoning proceed. I just can't remember what one it was, but it was very close in your rebuttal, I think. So what I'm trying to get at is what is it about Silverstream in terms of the water capacity restrictions that take it out of that approach that I've just quoted, and we've got the engineer here to assist. So just a forewarning on that.
At paragraph 305, about halfway down, where you disagree with the relief sought by the submitters, and you mentioned that the LRZ building coverage standards of 35 is appropriate, given the intent to be a lower density. 35% is actually quite a lot of site area covered by buildings. If you look at the pre-MDRS Wellington City District Plan for outer residential, is what they called it, that was the site coverage for 3/4 of the housing stock in Wellington City. Large lot, presumably it's a smaller building on a larger lot, and 35% is quite a lot. So can you remind me where the 35% came from the large lot residential?
So the 35% is what is already in the PDP.
Yeah, I understand that. I'm just wanting to know where that's come from. I know the submitter wants it to be more, but where did the 35% come from in the first place in the PDP?
I think that's probably a rollover from the operative plan provisions for the hill residential and landscape.
35%.
I can check that. But
Yeah,
a lot of these
I am just
standards
interested in that.
Yeah.
Doesn't appear to be particularly low density. Perhaps you can just check and come back to us on that. Right, we're then into building height in relation to boundary, setbacks. Uh, 315, I'm on. In landscaped areas, permeable surface, outdoor living spaces, just got a question about the circle with a diameter of 3 metres, at least 3 metres, paragraph 328, and you recommend accepting the relief sought and amending HRZSA Do other plans use a circle rather than a dimensional area? It's newish to me.
I don't think the other plans in the region do.
No.
I can double check that. Yeah.
But you support it in principle, it is better for getting a reasonably usable piece of open space.
Well, I think the submitter was seeking more flexibility, and I sought some advice from us more around that as well.
Yeah.
So based on that advice, I was comfortable with the amendment.
Oh, I can just add, I can't remember off the top of my head, but I've certainly assessed the diameter approach and other plans. I feel like it could be Gisborne, maybe, or in the Hawke's Bay region, there are some. You see either or, as I said in my evidence, there's sort of trade-offs for either approach to them, so I was just comfortable with either myself.
So these, the standard proposed would be more lenient than the MDRS then. In actuality, even though the MDRS uses a square metric as opposed to a circular metric.
Yes.
I wouldn't mind seeing some examples from other plans and the thinking going through that, because as I said, I was quite surprised to actually see it certainly in the Wellington region context.
I can look it up and get back to you, but there's definitely plenty of design guides that use the image of the circle, so I will go seek reference.
It may be that Christchurch City might use the circle approach, I believe, but you may want to check that.
Okay, moving through, I'm at para 330, windows to street. New standard sort.
Yeah, I just had a couple of questions about the FENS, more to do with their emergency service towers and communication poles. So you say as long as they're on the same site, you consider an exemption as appropriate. However, I know in the rural zone, the officer retains the setbacks and rejects the submission. So I just wanted to understand why the difference, the difference there.
Yeah, so to be honest, this wasn't a matter that we actually have discussed. So I think in the interest of consistency, it might be something we need to confer on and come back and reply. But given, I guess I come back to my statement in my report that they are a critical service, and in an urban area, emergency service facilities are fairly common, although I note, as I've said in my rebuttal, in Lower Hutt, they are zoned mixed use, not residential. And so in my view, it was something that should be provided for. There should be a pathway through for those facilities, notwithstanding I have amended that recommendation in relation to height and in relation to boundary and setbacks.
Okay, I've gone way up to 342. Before that. Yeah, I'm at the section non-residential activity rules, para 354. talk about childcare centres, 377 to 379, and where the 5 versus the preferred 15 by some people. So the 5 is not really too many people, is it? You could have a large family with 5 kids, and you know, and so forth. And so where's the 5 come from? Is that just rolled over, is it, from previous plans?
I suspect that is the case. Again, I can
Because
double check that.
most of them tend to be of some scale now, sort of 50 kids sort of thing. And usually there is a preference for them to be in, you know, a residential environment might not preclude a childcare centre from establishing because it's in a residential environment. Some would say it's actually better to have it in a residential environment than anywhere else. And just clarify where the 5 originally came from, and because so if you want to have a childcare centre with 6 children, a resource consent will be required.
Yes, as restricted discretionary.
Mm.
Yep.
Okay, just some sort of an, if there isn't any analysis, then that's fine, but it would be quite interesting just to know where that's been set, whether that's industry guidelines or whether it is rolling over from the existing district plan. But it does appear to be very restrictive for what potentially could be a smaller number of children. Educational facilities, emergency service facilities, outdoor storage and work areas, servicing, some recommendations. 391. Um, 412, in relation to retirement villages, when you are proposing some changes in relation to submissions, the changes to clause 3 provide affordable and efficient provision of assisted living and care services. Is it the role of the district plan to have a policy relating to affordability?
Potentially not. I think now looking at how the policy was crafted before my recommended changes, it was about enabling retirement villages where they achieve these things.
Yeah.
And I've changed it to be more directive around provide. So yeah, I would say that clause 3 is now providing affordable housing is not really within the remit of the district plan
No,
to regulate.
and certainly plans have moved away from that because in relation to multi-unit development, some plans in the past tried to have provisions in them that they should be, a certain percentage of them should be affordable, and there was a definition of what affordable could be or available to certain sectors of society. So again, it was because you've made a change to that, it brought my eyes to the word affordability and wondered whether that was suitable for the district plan.
Yeah, no, I'm happy to reconsider that. Yeah, had
Thank
thought
you.
that one through. Yep.
It's now 11:15, so we're about halfway through the morning session. I think we're actually making quite good progress here. I'll suggest we take the morning tea adjournment now for 15 minutes and come back at 11 o'clock. Thank you. We'll recommence hearing stream 3. And so we were at retirement villages, and we'll just work our way through the remainder of the 42A report. On to the rezonings. High density residential, Petone. Yeah, Eastbourne, so that's. So we're right through to 478.
I'll kick off if
Yep.
you like.
Good.
Before we get into the individual rezoning recommendations, Ms. Pascal, I wanted to just have a chat to you about your paragraphs 478 through to 483, where you've provided a useful outline of how you've evaluated the zoning requests. And I've detected a sort of a 3-stage approach where at 479 you talk about the zoning pattern, accessibility, capacity, transport, those sort of things. In 480 you go back to the ODP zoning and what was landed at PC 56 and any overlays that introduce constraints. And then at 482, sort of third level, was how does it fit with the overall consistency with the zoning strategy? So sort of a sense test at the end, if you like. And then on the constraints matter, you say that they're not, doesn't automatically mean they're downzoning, particularly if there's some solutions that can be worked through, and you give slope stability as an example there. And I guess the two things for me is, have I summarised that approach correctly? Is that the way you've tended to approach each of the zoning requests?
Yes, that's correct. In terms of the large lot residential, it was specific focus on those matters I've set out in 479. Those were sort of the primary, I guess, as you've described it, the first step, and then looking at, if it sort of passed those sort of tests, then looking at zoning pattern and how that
Sure.
would work. Yeah.
Okay, no, thank you. That's really useful. And was that a framework that you developed, or was that framework implicit in the 32 when any zoning changes from the ODP were contemplated?
My understanding is that the matters at 479 were well, it's not my understanding, that is what is in the Section 32
Okay.
report. I think the other matters may have been considered. I'm not sure if it's actually explicitly stated in the Section 32, however.
Okay, but certainly 479 is your starting point, and it was the starting point in the 32. Yep. Okay, that's good. Now, in terms of the slope stability, you say that that's been informed by technical advice, and that's the study that was done in 2021 by WSP. And does that overlay now replaces what was previously in the whole residential and landscape protection overlay?
My understanding of those ODP zones was that, yes, slope stability was a factor that was considered
Yeah.
alongside those other matters.
Okay.
The slope assessment overlay of the PDP is broader than just those areas. It would incorporate medium density areas, for example.
Sure. So, just so that I understand it correctly, if you can land a zone, whether it's large lot residential or medium density, you're satisfied that where the overlay intersects with those zones on the ground, that doesn't necessarily require a downzoning of that zone. That introduces a process and an assessment process for assessing development at the consent stage. Is that the approach that's inherent in what you're saying?
Yes, and that is how the proposed plan is intended to
Okay.
function.
Yes. Okay. Right. So those slope stability isn't necessarily a qualifying matter for downzoning. In other words.
That's correct.
Yes. Okay. Okay. That's yeah. Thank you for that. I struggled with those questions, but your answers are what I was assuming to be the case. Thank you. Okay, that was all I had on that, Lindsay. Thanks.
Okay, I'm at para 485. In Petone. Eastbourne and the Bays. So just looking at the Eastbourne ones, in general, there has been primarily a more finer grained assessment of the ODP zoning which applied and then transferring it into the new framework. Is I correct there? And there is some changes proposed. So have you yourself or others gone out individually, looked at each of these on site to determine or not whether the zoning was appropriate in terms of the framework which applies to each of those zones?
Yes, I have.
I have to say, we will be doing some reasonably comprehensive site visits relating to this hearing on Thursday. Okay. Your paragraph 504, we talk about the highly constrained roads overlay at the top of page 131. The council has determined there are significant limitations on access. They're not very widespread in the plan though, are they? You turn the overlay on, only a few pockets in a few different areas of the Western Hills and Eastbourne where that applies. What couldn't there be another mechanism to achieve the same, like through purely zoning? Zoning will dictate the density rather than needing to have that. I presume that's part of the infrastructure and transport hearing stream as well, but it is quite relevant to the general zoning which applies in residential areas. Can you expand a little bit more about what the thinking was?
So I have limited knowledge of the highly constrained roads overlay, other than to say that my understanding is it's quite a high, the methodology that's been used, so that's actually quite a high bar that needs to be met for something to be considered highly constrained. And that is probably a question for the reporting officer of the transport infrastructure hearing. But I understand your question around would a downzoning approach be more appropriate. I haven't really turned my mind to that, given that the overlay is there. Whether that should or shouldn't be included, I think isn't something I've really turned my mind to.
Okay. It might be something we follow up in terms of this hearing. Although I personally am not on the transport hearing stream. It's the one hearing stream I'm not doing, but my fellow colleagues will be. I just wondered, has it been used elsewhere? What's the utility of it? What is the particular, couldn't some of the outcomes achieved by the overlay be achieved by a zoning or a more restrictive zoning? Okay. Sure.
I got a little bit confused, Mr. Pascal, about the Eastbourne and the Bays submissions. They're quite complex, aren't they? Some wanting some upzoning, some wanting downzoning. Group submission from Sensible Solutions, the York Bays Residents Association. Some sites are already zoned in line with the request. Other sites aren't. And I just wondered, I guess my question is, your attachment 3 is really useful and it's going to be a good guide for the panel. Have you had an opportunity to update that since your 42A and based on your rebuttal and your summary?
No.
Do you think you
Other than
could?
the full set of maps I've provided, I haven't
Yeah.
gone back to the assessment. Is that, if that's your question?
It's the attachment 3.
Yes.
Assessment of zoning request for MRZ to LRZ, and I think it should be LRZ to MRZ. You've actually repeated the title.
Right.
Yeah.
Okay. So sorry, what
I
is the
wondered
question?
whether you could update that, the contents of that, to reflect your latest position.
Okay.
Yeah.
Yes.
Yeah, there might not be many changes, but if there are any changes as a result of evidence and that you've identified in your rebuttal,
Yeah.
that would be useful.
Okay.
Okay.
Thank you.
Well, I'm up to para 509,
Yes,
large lot residential.
yes.
The 12 Shaftesbury Grove, it's not just a rezoning to medium density residential. There's some sort of additional provisions which still apply. So you're suggesting they get carried over to the existing medium, the MRZ zoning. What's the reason for needing particular precinct provisions? Is there such site-specific peculiarity in terms of that site which warrant an exception to the general rule?
That is my understanding. That was a private plan change request that became operative since the notification of the proposed plan. So my understanding is that those site-specific matters wouldn't have been incorporated into the proposed plan, which is why they've come through a submission.
Are they more restrictive than medium density residential in terms of those additional matters?
I would need to turn my mind back to that and
Okay.
come back to you and reply.
Just on that, your recommendation is to include the reference to the precinct in the MRZ chapter introduction. But you note that the amendments sought to other chapters such as subdivision will need to be addressed later on. So presumably in the subdivision chapter. Yeah. Okay. Okay, that's fine.
Uh, 512. Then we're talking about 452 Cambridge Terrace, 515.
Yes. So 443, you don't address any further because it's already zoned in like.
That's correct.
Yes, okay. Right, so we can just focus on 5452.
Then we're on to 320 Eastern Hut Road. If you actually punch in 320 Eastern Hut Road on the district plan viewer, it doesn't come up. I'm just wondering whether it's got an alternative reference. It does, I think if you use, what's the name of the side street which comes?
Reynolds Batch
Reynolds
Drive.
Batch. If you use that to get to where you need to, you can find out where it is. It was a little bit confusing at the start, resolvable. Any questions about 320
Yeah.
at this point? You've got them more in rebuttal rather than.
Okay, deal with it then.
Yeah. Holborn Drive. Crawford Grove.
Oh, sorry, just on Holborn Drive. Pascal, I just picked up that you might be a little bit ambivalent on your recommendation here at 525, where you say, should the panel take an alternative view about the rezoning there? I've marked up the diagram that appears above 524, and there's some common boundaries between 60 and 66 and the existing zoning pattern along Holborn Drive, isn't there?
Yes.
So if the panel had an alternative view of amalgamating 66 and 60 into the zone as requested, those four or five bullet points that follow might support that. Is that what you're saying?
Yes, they may do, although I would note that you would then have 202 and 200 would be large lot, sort of a bit of an island.
Yeah.
But, you know, I guess it's in terms of, like you say, common boundaries between the two, that could be an option, yes.
Yes. And 1/54, I think, is the other site. That would be, wouldn't be directly adjoining, it would be across the road from Holborn.
Yes,
Yes.
yeah.
Okay.
In amongst a number of large lot.
Yep.
Yeah. So 60 and 66 would make more sense.
Yes.
Yeah.
And is that where that third test of the zoning pattern might
Yes.
come into play?
Yeah.
Yeah.
And I suppose I had considered that 60 and 66 could be rezoned medium density, but I was concerned by that 200 and 202 sort of being left out.
Yes. Putting aside the zoning pattern, are there any other reasons why, in terms of the site constraints, etc.?
No, I mean, I do note in that paragraph 525 that, you know, this is an area that has been the subject of recent slips, but there is the slope assessment overlay, and I understand there's been remedial work undertaken on that section of Eastern Hut Road. So that wasn't a determinant.
No, and you said earlier you could rely on that.
Yeah.
Yes. Just remind us, what's the zoning of 60 and 66 and the ODP?
I believe it's Hill Residential.
Okay, yeah, which makes sense. Yep.
Be fair to say your job would have been made a little easier if there was a comprehensive submission which covered all of these properties rather than.
Yes. So there is a scope issue there, yeah.
Yes, there
Yeah.
there is a scope issue.
You made the good point earlier in relation to the Eastbourne properties that many of the properties that have been sought to be rezoned by the global submissions hadn't had any response from the property owners themselves. And you were
Correct.
cognizant of that.
Correct.
Yeah.
Okay. Crawford Grove, Russo Terrace and Totra Street. Mackenzie Road, Walter Road. And then we're into the medium density residential zone. Major Drive, Kelson. Just wondering whether that should have been in the previous hearing stream, that one, but,
I think it might have missed the,
Yeah.
okay.
missed that report, hence it's been included here.
So I have a question on that one. Are there any directions regarding notification for development on that site? And there's a submission from, I presume, a concerned neighbour,
Yeah.
that area.
I would need to check that, but off the top of my head, I'm not 100% sure, but I doubt there would be. That's generally not the approach the plan has taken. But I can come back
Yeah.
to the panel on that matter.
Thank you.
Just going back to that Major Drive one, is the request from mixed use to medium residential?
Yes.
Okay. I wonder if the submitter appreciated that it was being dealt with in this hearing stream and not as opposed to the preceding one.
That's a very good question.
Because originally I thought it was a typo. I thought MUZ, I
Yes.
thought you meant MDRZ, but no.
I mean, my understanding from how the council officers are notifying submitters is that those that are listed on the,
Yeah, okay.
in the appendix are the ones that are notifying, but we can check around that.
Para 545, Korokoro, Stanhope Grove and Rakiora Grove. Okay, I am at 556. Then we're into Wainuiomata. Belmont.
Question there, Lindsay.
Yep.
These large number of submissions seeking the rezoning of properties on Park Road, is that from MRZ to large lot?
That's correct.
Okay. Okay. And your recommendation is in part to make that change, but in part to retain MRZ. Is that right?
For these ones, I think it was yeah, that's correct. Yeah,
Yeah.
so Mr. Benner has given some evidence around a group of properties which were subject to one or two, or quite a few submissions, but quite comprehensive. And the remainder are to be retained as
Yes.
MRZ. Yeah.
And if I go to attachment 3, I'll be able to see
Yes.
those. Okay, thank you.
And so the reason why the wider area wasn't looked at is just because there's no submission, it's a scope issue.
Correct.
And are you comfortable that the submissions received are comprehensive enough? Like it covered all of the properties, all the property owners supported it, there wasn't any outliers there? Thinking about Holborn, The approach that you took in Holborn was that it was not all of the property owners were submitters. This one here, and perhaps we can ask the submitters when they bring their team tomorrow, the same question, but do you know offhand
I
whether
don't
it
know
was completely comprehensive or not?
I don't know offhand if the owners of the properties that were listed were specifically in approval of those submissions. I guess I took it as read for those ones that they were. The Holborn and I think it was Eastbourne submissions, there was a general relief sought around rezoning all of the large lot properties in Eastbourne to MRZ, and that was the one I was concerned we hadn't had anything from property owners or even specific submissions around specific sites. So that was the difference there. But yes, it could be a question for the submitters tomorrow.
Okay, well, we'll follow that up. Mr. Benner has also provided comment on the Park Road issues. We've read that. I don't have any specific questions of Mr. Benner at all on this property. No, okay, thank you. Kaitangata Crescent, Kelson. Mary Street. And then a number of recommendations. Miscellaneous matters.
Nothing more for me.
And nor from me. I think we'll probably take Ms. Moore's appendix to your section 42A, and we'll see if we've got any questions now. And then probably Ms. Moore, once we've done that, you can probably go if you wish. So did you just like to give us a brief overview of the evidence that you provided to us, and we'll go on to questions after that.
Sure, I haven't prepared a summary statement.
Well, I
but-
don't think I realise that, but probably just hit the few highlights, if you like, because you've answered some questions as we've been going along, which are related to the material in your evidence as well.
I think for me that probably the primarily matters of contention as sort of discussed today was my recommendation to sort of enhance policy so that landscape treatment and streetscape amenity came through stronger, particularly in regard to the approach of the plan to not have statutory design guides, having those clear outcomes in the policy and applying consistently across both medium density and high density in terms of that streetscape amenity policy for P12 and P13. I agreed with the plan as written that it's not necessary that there is a design statement required just because of that sort of the process alignment with not having statutory design guides. However, I think sort of as we've spoken to about sunlight provisions, if there are matters of discretion that sort of require that urban design input, I think there will be place for that within an assessment of environmental effects itself, and I would expect an urban designer to be brought on board for those. And if council felt that it required one, they could go back to an applicant on that merit and ask for a more comprehensive, not necessarily a design statement, but just to have those aspects of the plan spoken to. Again, probably that retaining reference to shelter. I thought that's a good one, that where there's an absence of design guide, that's the kind of thing that can help contribute to legibility and to building form as well. Just refining that policy around avoiding wasted spaces and just changing the language to make that clearer about site layout, which I think will be enhanced through a design guide that can speak to what that means outside of the plan. And again, I was comfortable with the 3-metre diameter, but for me, that's an either or. I've seen them both used, and I think there's trade-offs with each, and both have merit in their application, so I was comfortable with the recommendation.
Any questions of Ms. Moore? Okay. Probably move on to your rebuttal now. Sorry, Ms. Moore. There may be matters arising in the rebuttal as well, rather than you being able to go now.
Yeah, that's all right. Thank you.
Thank you. Right, I've just got to get that. Right, just moving through the rebuttal statement. I'm at 310, Silverstream Christian Centre. Just in terms of the existing precinct, it probably there's been a bit happen before on this site, and so we've got a precinct now. And there's been recent resource consents granted. So you've been able to think about that context in terms of your recommendations here.
Yes, yeah, so I have considered that.
And in terms of the split of the zoning, combination of ODP, precinct provisions, slope stability, all those things have led you to a conclusion that there should be a split zoning on that particular site?
Yes, I mean, that is based on, primarily on that water supply issue. I think if that could be resolved, then there is potential for that large lot area in the southern section to be medium density, but at this stage I'm not satisfied that that issue's been addressed adequately.
Right. And also that southern part of the site has alternative access as well, from, just trying to think of the name of the street.
Kingsley. Yeah.
Street. So there isn't any existing resource consents which apply to the southern part of the site that you're aware of?
None that have been through the entire process. So the submitter had an application in 2024, I believe it was, which they subsequently withdrew and chose to pursue this rezoning option. I'm not across this particular reasons why the consent was withdrawn, whether that was infrastructure servicing or some other reason, but yeah, that's the extent of my knowledge in terms of consents on that section.
But there is a large amount of alignment between you and Mr. Cooper.
Yes, correct.
Okay. Any questions on Silverstream? Because we might ask Mr. Aitchison to chip in on this because he has considered it.
So just returning to the conversation we had earlier, I from your rebuttal, which I thought was very well explained, I got the impression that it was solely water supply and the capacity and supply that was creating a barrier to you recommending the change in zoning from LLZ RZ to medium density, and that you'd resolved with the assistance of other experts and the evidence provided by Mr. Cooper and his team, all the other matters such as slope stability, transport, etc. That's the situation?
That's correct.
Yes. Okay. And I guess the question that I posed earlier is, Mr. Atkinson says that while detailed design for the internal water supply could be resolved at the detailed design stage through the consent process, more work is required to demonstrate a feasible and reliable water supply from the public network that can support a medium-density scale of development with individual areas. And that Mr. Atkinson is of the view that that should be addressed prior to rezoning. And I contrasted that with the statement that you made earlier, that these sort of issues can generally be dealt with through the consenting process. And I noted that there was another rezoning, and I just can't, it's probably not covered in your rebuttal, it might have been in your 42A, where there was a water supply issue that you did say could be handled through the design process. Can you recall what that was?
Yes, I think it was there was the Cambridge Terrace.
It was Cambridge Terrace, yes.
Request.
Yeah.
Yeah.
Thank you. And what I'm really trying to understand, and this isn't supposed to be an inquiry or anything, but what's so different about the water supply issue for this site compared to the Cambridge Terrace site that means that the issue can't be dealt with through the consenting process, and the rezoning for at least that portion of the site should stay at LLRZ, because obviously that vacant part of the site's probably got the most scope to develop in terms of medium residential, if you take into account what's happening already around the retreat. What, in your point of view, and we'll ask Mr. Atkinson also, what's the key reason for the differential there?
So the advice that I received initially to inform my 42A report from Wellington Water was that the sites are actually quite different in terms of infrastructure, availability, connections, etc. And in terms of the Cambridge Terrace site being within that sort of Nainai area, those constraints appeared to be more readily able to be addressed through the consent process, not reliant on a private network, as is the case with the Silverstream retreat site. So whilst I think I acknowledged in my report that it's not without its, there are issues still to be resolved with that Cambridge Terrace site. I was more satisfied that that could be dealt with more readily, whereas with the Silverstream retreat site, I considered that rezoning to a medium density zoning actually sends a signal that it's sort of infrastructure ready or relatively, not simple is probably not the right word, but there is a pathway available. I wasn't convinced that that was the case for the Silverstream site, and Mr. Aitchison can probably provide more detail around the technicalities, although he hasn't had the benefit of reviewing that Cambridge Terrace site. We'll note that.
Okay, so what I'm taking from your answer there is Cambridge Terrace, even though it has some constraints, isn't reliant on private network reticulation and solutions, whereas Silverstream has a mix of public and private at the moment, and there's some uncertainty how that might develop in the future.
That's correct.
Okay.
I also thought that there was something of an issue in that the sites are all in one land ownership. If there was going to be a rezoning, there'd be land fragmentation. There's possible individual landowners from the residual lots who might not be able to comply with some of the potential big ticket items in terms of water supply. And I'll ask Mr. Aitchison that too, as being a constraint. And it's not uncommon position taken by Wellington Water, in my experience, about concerns about subdivision and urban development, which puts a lot of onus on private property owners to actually deliver, whether it be wastewater or water supply. So that is a key characteristic of this site as opposed to anywhere else.
That's correct, although I suppose the Cambridge Terrace site is currently in that single ownership situation, but not reliant on that private network that exists at Silverstream site.
A little bit different though in terms of scale and slope and things like that too. Okay. Mr. Aitchison, welcome. Have you got anything more particularly to observe? You've been
Yes.
hearing some of the discussion that we have here, and you've read the evidence of that we'll be hearing from tomorrow.
Yep.
You got any observations that are helpful to us at this point?
Sure. Just concentrating on water supply, if you like, as opposed to the other three waters. With the water supply, I guess there's three aspects to it that what make water supply work. One is having enough pressure, one is having enough flow, and the third one is having enough supply. What's not clear at this stage is the availability of supply for the additional rezone land. At the moment, the management of the reservoir is based on current use, and so what's needed really is an understanding from Wellington Water on their availability to be able to service the site from a supplies perspective. We agree that from a pressure perspective, there's enough elevation there for it to work, although I understand it's quite marginal. And with regard to flow, that's basically to do with pipe sizing. So those two aspects can be addressed as part of a future resource consent. The third one is more difficult and involves perhaps quite significant infrastructure if supply is not found to be available.
Again, so Wellington Water I know they're not here, but they have done some supply analysis in terms of existing demand and what projected future demand is in this part of Hutt City, the very northern part. Presumably there's a relationship with Upper Hutt as well, with the conclusion there, well, this is unplanned development and therefore water supply needs to be provided. How's it going to be provided and who's going to pay for it? And that's your understanding of Wellington Water's position?
I'm aware that they have done studies. They haven't provided any information of this particular reservoir in this particular zone about what availability there is, but we rely on them to inform us of availability.
And the same issue applies in the rural zone as well with Wainuiomata.
No, that's we've actually got they provided advice on that particular, that there is a upgrade available to support that rezoning.
So, but it's planned, it's not funded though, is it? It's the difference.
I believe it's in the council's long-term plan.
Okay.
Yeah.
All right. Questions, Mr. Aitchison?
Yeah, a couple from me. Thank you, Mr. Aitchison. That's useful, and particularly your observations about pressure and flow, and puts the matter squarely on the supply aspect. Just from my lay understanding, what's currently there in terms of the reservoir, and is it a public or private one?
It's supplied by a public reservoir. It's about 2,500 cubic metres.
Yep.
It's not a big reservoir. Along with the capacity of the reservoir, there's also a question about the supply to the reservoir and if there's available to increase that supply to that zone.
Okay.
So that's, again, a question for Wellington Water. And
Yeah. So two aspects of supply, getting water to the reservoir and
Correct.
its availability, and then the capacity of the reservoir itself to retain
to
it.
cope with daily
Yeah.
demand. Yeah.
Okay. These are questions I'll probably put to the submitters expert, but to deal with that, what's the logical infrastructural response? Is it to build a larger reservoir?
Normally a bigger reservoir, yes.
Yeah. And that would still you'd still need some satisfaction that you could get adequate supply to that holding reservoir.
Correct. Yeah.
Yes. Okay. Okay. Are there other localities or properties or groups of properties in the district that you're aware of that have similar constraints?
Yes, and not necessarily in Hutt City, but in Upper Hutt, I'm aware of a project I was involved with where it constrained the development such that the development went to roof water supply because
Sure.
there wasn't enough capacity.
Yeah. Is that a potential solution here, or is the scale of development preclude that?
Yeah, so potentially with the requirement for storage, you would need larger lots to cope with the water tanks.
Okay, understood. Okay. And is it important in terms of these infrastructure solutions, particularly with the reservoir, whether it's in the public realm or the private realm in terms of the provision of such infrastructure?
I understand it's important that if it's a residential types of development, then it should be in a public realm.
And what was your comment to the chair earlier about funding in terms of?
There is a rezoning in Waitemata, which at the moment Waitemata has a lack of capacity,
okay.
but there is a proposed upgrade that will.
Yes, I understand.
Yeah.
Okay. Okay, so there are solutions, but there's this uncertainty as to how they might come on stream. Is it the planning period for this district plan is, well, possibly around the 10-year horizon? Presumably the situation could change in that time and adequate infrastructure could be provided?
There would be that'd have to come from Wellington Water.
Yes,
Yeah.
okay. Thank you, Mr. Atkinson. Just come back to you, Mr. Pascoe. Had you thought about the possibility of a deferred zoning in this case in terms of a precondition that required the water supply to be dealt with and that no allotments or no subdivision down to a certain level could occur until such stage as? I've seen those techniques used before in terms of traffic limitations and other infrastructure. Is that something you've turned your mind to?
I hadn't thought of a deferred zoning. I think that there is a general practice of moving away from deferred zonings, but it's whether there is, I suppose, I could consider whether there's something through the subdivision rules that could address the same intent as a deferred zoning. Correct. Yeah. Yes, it would. And I suppose that the PDP, as far as I'm aware, has sort of not done that sort of site-specific, taken that site-specific approach, but it doesn't mean it can't. So that is something I'm happy to turn my mind to. Yep. Correct. And I suspect that might be the reason why the earlier consent was withdrawn, because of the policies, objectives and policies of the Hill residential zoning. Potentially, and I'm open to doing that. I know late last week on Friday, in fact, Mr. Godwin did actually reach out to Mr. Aitchison around some specific technical matters. So there is a willingness there on both sides, I think, to do so. So I'm happy to do that. Yep.
Yeah, I think things may be a little clearer when we hear from Mr. Godwin tomorrow. Right, moving on through the remainder of the rebuttal. Fire Emergency New Zealand, we had some discussion about that before. That's it. Yep. Well, thank you for that. Just looking at the time, my original hope that we would get through both 42A part reports before lunch is not going to happen, but I think we should perhaps start with the rural zone now. Unless there is anything that any of your group wish to comment on from this morning that might be of use to us, we'll have a think about it anyway, and there may be some follow-up questions. Okay. So who's leading the charge, Mr. Horrell or Mr. Bellamy?
We did plan for me to start, just to give that general overview.
Yes.
I guess a question for the panel, if they would want to continue with the flow of rezonings. Mr. Bellamy is the reporting officer for that.
Yeah. Well, I'm just thinking Mr. Ben has been sitting down there without having to contribute anything this morning. And if we perhaps deal with the Upper Fitzherbert, Wise Street issue, and then perhaps both Mr. Aitchison and Mr. Benner can depart, that might be helpful. We'll just head straight to that. So perhaps Mr. Bellamy, if you just want to just give us a brief introduction on that particular issue, and then we'll go for questions. And in the meantime, I'll find the relevant reports.
Do you want me just to skip straight to the summary of that particular issue, and I'll do the rest of the outline?
Yes, that will be helpful. Thank you.
Okay, my name's Sean Bellamy. I basically have been involved in the review of the rural zones. I'll just quickly cover the rebuttal evidence and summary. Summarise the situation with the rebuttal evidence on the site at 104 Upper Fitzherbert Road. So the site's being rezoned from rural lifestyle zone to medium density residential, and considering the relevant rezoning requests, I've relied on evidence provided by Luke Brenner, who's the traffic engineer for LBC Traffic Engineers Limited, and Matt Atkinson from Engineering Planning for Three Waters and for Transport. Matt's evidence on transport is pretty much localised, whereas Luke's is a bit broader. My apologies if this is a bit out of joint. I'm kind of changing where I thought I was going to start.
And that is my fault. I just thought it was nice and discreet issue we could perhaps deal with before lunch.
So in terms of the Section 42A report, I'm going to start reading from page 7, which is issue 2, the rezoning of 104 Fitzherbert Road Upper Fitzherbert Road from rural lifestyle zone to medium density residential zone. FH developments. The rebuttal.
Yeah, just hit the high points if you like, rather than reading stuff verbatim.
Okay, sorry, that might be a bit easy, otherwise I might get around in circles a bit. Essentially, it's a rezoning from, they're seeking relief for rezoning from rural lifestyle to medium density residential. It's an Upper Fitzherbert Road. It's on the boundary between medium density residential and rural lifestyle zones. The key points of contention in terms of zoning I consider to be Three Waters and transport. The other issues aren't as significant because essentially it's on the zone boundary and it's already been used for farmland, so things like the ecological values are not that great. But in terms of transport and Three Waters infrastructure, the things that we were concerned about were the effect on the transport network in terms of the increased demand from extra houses, the potential issues to do with water supply, which have already been discussed, also an issue with wastewater disposal in terms of the capacity of the system in that area, and lastly with the effect of flood or stormwater runoff into Black Creek. So those last three issues were significant enough that we asked for a review by technical experts. The information that was supplied by the submitter post section 42A, so it's quite a fast turnaround. So rather than summarise what the technical experts have said on those three issues, I'll let them speak to it. The last thing was that given the transport issues, not just with the impact on the transport network further down, but the potential to develop, further develop residential development in the future up the valley, which required some kind of transport route through this particular piece of land because there are issues with Upper Fitzherbert Road. The planner, Miss Wynne, suggested a specific rule in the subdivision chapter to essentially limit development or make it more difficult to get development if the Wise Road had not been transferred to road reserve and then formed. So that was an essential part of the proposal. So there is a associated subdivision rule that's bespoke to that site. I've also suggested that it's probably more appropriate for the rule to be restricted discretionary as opposed to discretionary, as opposed to controlled.
Okay.
Hopefully that has been able to be followed quite clearly, and I haven't.
No, it is clear. There's been a bit written about this, not only by council officers and advisors, but also in the evidence which we'll hear tomorrow. What I think would be good to actually focus on is the issue of infrastructure supply and transportation as a context. But it seems to me council was not averse to supporting, or council officers are not averse to supporting a rezoning subject to other things being resolved.
That is correct.
Yeah.
My position is I can support it if they can address those issues with transport and with infrastructure.
Yeah, okay. Should we talk to Mr. Aitchison and Mr. Bennett now, I think? Okay. Mr. Aitchison, we had a brief discussion about Upper Fitzherbert Road before. Have you got anything more to add in terms of that? I think you conclude that subject to water supply, and a normal consent assessment for subdivision and urban development, that the site is appropriate from an infrastructure servicing point of view?
Correct. There are some challenges to the site, given the flooding and also the not having access to Wise Street at the moment would probably be the two main aspects that make development difficult. But that they are matters that can be resolved through the resource consenting process.
In terms of access to Wise Street, though, isn't that Wise Street subdivision, which is currently being developed at the moment, doesn't that have the stub road which connects through to the adjoining site to the north, the subject site here?
At the moment, it's not legal road; it's road reserve, and it's unformed. And
There's no spite strip or anything stopping. You know what I mean by a spite strip?
Yeah,
isolation
correct.
strip,
No, there's
ransom
not.
strip.
No,
Those sorts of
No.
techniques which have been used.
Yeah, so it would just need to be vested as road and formed, or formed and then vested
And,
as
and
road.
that's a condition of the current consent for that property. Okay, all right, thank you. And we talked a little bit more about water supply and that. I was particularly keen. It's all very well to have, say, there is going to be a reservoir built, or there's going to be a new alternative source of water supply as justification, but that really needs to be backed up by some pretty hard action in terms of, you said it's actually
LTP.
in the annual plan process. Do you have any idea of projected year for that?
It's currently funded for design, but there's no construction date set yet.
Okay, and so that will come through in a future annual plan process once design is there and some numbers are formulated and potentially also fitting in with financial contributions as well.
Yep, correct.
Okay. Questions, Mr. Aitchison? No. Well, thank you for that. Mr. Benner, again, having read yours, you're broadly supportive of the proposal, subject to your concerns about the capacity constraints on a couple of intersections, which are, I would observe, are reasonably remote from the site.
Yes, that's right. So while they're substantially sort of downstream from the site, they are the main intersections that would receive that traffic flow. So depending on the level of yield, may dictate how those intersections perform during peak times. So that's kind of the area of interest, I think, and it needs to be explored either, through.
So should that be? It's probably my one issue that I have with your evidence. You say that future capacity upgrades will need to be explored at a future time. How would that actually transfer across the district plan provisions applying to the site?
So I think that needs, well, put it this way, I'm not necessarily saying that the intersections will be constrained. It just needs to be analysed in further detail. So it's such to say, if this was to be rezoned and the applicant were to lodge a resource consent application, I would expect to see a modelling assessment or similar undertaken to assess those effects of the intersection, and it might show that the level of service is such that no mitigations are required. But that hasn't been performed in this rezone request, and as such, I can't comment on
So
what level of mitigation might be required.
that's something we would put to Mr. Wilkie tomorrow. Do you know if council, as road controlling authority, has any active investigations in terms of the safety or capacity issues of those intersections in question?
I'm not aware of any focus there currently.
But perhaps in the right of reply that could be followed up and seeing whether there's any accident record, whether there is any issues of particular capacity being identified at the moment, what has been taken into account of existing zoned and planned development for that northern Wainuiomata Valley. I think it will be quite important to actually establish that Because you've raised the reservations about potential capacity because you don't have the information.
Yep.
All right. Any other questions, Mr. Bennett? Okay, well, thank you for that. In terms of other matters to deal with up at Fitzherbert Road, and turning back to you, Mr. Bellamy, there's reference in the evidence about a Northern Wainuiomata future development strategy, or I can't remember the exact term to it, the 2018 document. Has that influenced the zoning pattern in that area? Are you familiar with that strategic study which was carried out?
I would have to refresh myself in terms of, off the top of my head, I can't remember the details, but I can get back to you on that.
Yes, well, it certainly has been raised. Normally, Mr. Goode may know the answer to this, but yes, yeah, be happy for you to field that one.
So a bit of background to that growth framework was the council has previously had an urban growth strategy that was dated from 2014, I believe, that was setting out how the city would provide for growth citywide in the future. And the northern end of Wainuiomata was identified through that growth strategy as an area of focus for greenfield development. We don't have a lot of greenfield development opportunities in the city. So that's sort of the last large-scale site that's available. So the growth framework was a piece of work to investigate how development in that area could play out to address some of the challenges with development in that area, to do with infrastructure, to do with how Wainuiomata as a whole would provide for the growing population, to do with fragmented ownership. So it tried to address those issues and did so to a fair level of detail about what the layout of a subdivision in that area could look like. And it wasn't just the site that we're talking about today. It was all of the northern end of the Wainuiomata Valley. While that was approved by council in, I believe it was 2018, it hasn't got to the stage of having an implementation strategy or plan or anything like that, and it's more sat as a council document in the background without any work program or actions to try to realise what that framework is showing. It is council's most recent document for the future of Wainuiomata North, but it isn't being progressed at the moment. Coming back to your original question, has it informed the zoning layout of the proposed district plan? Not really. The zoning layout of the proposed district plan is, for that part of the city, is largely rolling over what is in the operative district plan.
Okay, thank you. That's helpful. Any other questions on up Fitzherbert?
Well, Mr. Bellamy, seems that the remaining issue for us is the contest between the activity status for subdivision in the future. Ms. Wynne prefers a controlled activity and you prefer a restricted discretionary activity. Is the sole reason for your preference for the latter the ability to decline the application, or is it to do with more the matters of discretion versus the matters of control?
Primarily, I thought it was more important to have the ability to decline an application if necessary, depending on what the effects were. I thought that would give council the ability to avoid effects if necessary.
Okay. Your rebuttal cross-references to Mr. Horrell's rebuttal, and I think in particular the reference to his appendix that possibly contain some wording for that restricted discretionary rule. Was that correct?
Yeah, it is correct. It's also should be in Appendix 1 of my as
Okay.
well.
Thank you. That was all.
Any more? Yes, well, we'll be hearing these 7 briefs of evidence from the submitter on the table. I'm not expecting to hear from all of those experts tomorrow and have indicated to Ms. Wynne that we don't expect them all to present at the hearing tomorrow. Well, for now, we have no further questions on that issue. It's 12:10. Take the lunch and adjournment now. We've got some submitters coming at 1 o'clock, and then we'll proceed with the remainder of the rural area. So we'll adjourn for lunch until 1 o'clock. Thank you. Kia ora, everyone. It's the afternoon session of Hearing Stream 3. So we'll have a break from the reporting officers, and we've got 2 submitters this afternoon. The first being Waste Management New Zealand Limited, and I think we've got Sarah Whiteman. Okay, if you'd like to come up here. And we have Ms. Goodwin online again. Good afternoon, Ms. Goodwin. Can you hear us?
Yes, I can. Thank you.
Right.
Are you able to hear me okay?
Yes, that's all good. Thank you. Over to you. We have your briefs of evidence, and yes, so tell us what you need to tell us.
Thank you, and good afternoon, everyone. So just an introduction. My name is Sarah Whiteman. I'm the General Manager of WM New Zealand, also known as Waste Management. I work with David Howie, and David has submitted already in Hearing Stream 2. You would have just to help with the correlation there. And as you've said, I'm here today with Angela Goodwin as our planner from Potentialis, and we're here to answer any questions that you may have. I'm surmising most of those questions may be aimed at Angela, but I'm here in terms of that corporate evidence.
Okay, so in terms of your evidence, I'll just ask my colleagues, any evidence of Ms. Whiteman? No, and either do I. Very useful. I particularly like the way that you explain between the different categories of waste management activities. It was very useful to us, so thank you for that. And on to Ms. Goodwin.
So I'll just briefly speak to points where there's divergence between my evidence and that of the reporting planners. I won't speak to those parts where there's agreement. And just reconfirm, I have read the Code of Conduct for expert witnesses. I just note that in the rebuttal evidence of Mr. Bellamy at the start, it attributes the evidence of Enviro NZ's expert to WM. This just appears to be a typo. The relevant submission point was to amend policy GRUZ P2 subclause E to add urban development after rural development. And this was to reflect that whilst fill sites are a rural activity and they do contribute to rural development, they more commonly support urban development. And this is because most of the fill being disposed of at fill sites is from urban construction or infrastructure projects. And so the idea of adding urban development after rural development was just to perhaps better reflect the function of fill sites and how they operate. An alternative to that would be simply just to refer to development. Upon further reflection, I agree with the reporting planner's consideration that it's not necessary to recognise lawfully established activities or to add appropriate need in that same policy, GRUZ P2 or Objective 3. And that's the General Rural Zone Objective 3. Mm-hmm. My earlier opinion on these matters was related to ensuring that waste management facilities, fill sites and ancillary buildings were given appropriate weight at a policy level. And that's perhaps consistent with the NPS infrastructure. However, considering the rebuttal evidence of Mr. Horrell, I do agree that the changes could potentially water down the provisions of the zone as a whole and how they relate to other activities. Just moving on to GRZ Rule 17, I agree with the change in that title to remove solid waste transfer stations and amend it to waste management facilities. I note that Mr. Horrell suggested what WM's submission was that waste management facilities should be restricted discretionary because the effects can be easily defined. Mr. Horrell suggested that a grading approach may be an option, and that with waste management facilities over a certain scale being discretionary, and those under that scale being restricted discretionary. I've spent some time considering this. The main potential effects of waste management facilities are amenity, air quality, and traffic. Of these, district-wide rules control traffic movements, and there's a trigger in the notified plan, I believe, is 200 traffic vehicle movements a day, and then that requires consent under the district-wide rules. And there are also controls on new buildings that apply under the notified rules. So that includes building height, gross floor area, and setbacks. And I believe the gross floor area control is 800 metres squared. One option could be to make it clear that those building standards also would apply to a waste management facility. And so in the wider context, there are some additional, I guess, assessment criteria that apply to waste management facilities that are at a larger scale. And it's what we want to avoid is duplication so that the process stays efficient. I do, however, understand the concern about scale, and perhaps one option would be to add into the matters of discretion the scale, location, and intensity of the activity, and then that would allow the scale to be specifically assessed. I would, however, if you are of the mind to think that a graded scale approach would be appropriate, I would be happy to do further research on it to see what metrics would be best to use and what would sort of work best. And that's all I have prepared to speak to, but happy to take questions.
Great, thanks, Ms. Goodwin. Pass on to my colleagues.
Good afternoon, Ms. Goodwin. It's Commissioner McMahon speaking. Can you hear me okay?
Yes, I can.
Good. I just my sole question relates to GRUZ 17, and I guess there's three possible outcomes there. The one is the notified one, where the activity status for these facilities remains as discretionary activity. The next outcome is as per your relief, which is restricted discretionary. And the third outcome is the graded approach, where there's a distinction perhaps between a certain threshold and above that threshold, which would align with restricted discretionary and discretionary. Where are you currently in terms of those three options?
I think that the issue with the graded approach is trying to work out an appropriate metric for what the scale trigger would be. And looking at other plans and rural zones of other plans, generally for industrial activities in the rural zone, it tends to be based around building size or traffic movements. And looking at the notified plan, there's already those triggers there.
Yes.
So in that context, I'm not sure that the grading approach and having a discretionary activity status once it reaches a certain scale, I'm not sure if it would add value in the assessment.
Okay. So are you, on that basis, are you maintaining the status quo in terms of the relief sought in the submission?
At this stage, however, I do think there would be benefit. There's sort of had a little bit of limited time, and I have had a look at some plans, but there may be benefit in searching through and looking at what approaches other plans take to this issue, if we could pull any guidance from that, and if any other plans do use a sort of a graded scale approach.
Sure, understood. Looking at option 2, which is restricted discretionary, you identified 3 potential effects associated with these facilities: air quality, amenity, and traffic. And you suggested that the district-wide rules on high traffic generation and traffic would deal with that, and amenity would be controlled through new building controls dealing with height, gross floor area, and setbacks. And that leaves air quality. You've suggested the addition of a matter of discretion, which would go along the lines of the scale, location, intensity of the facility. Would that be the only change that you would suggest to support restricted discretionary activity on a non-graded scale?
Yes, at this stage, I think just to give some context on the amenity, so outside of the buildings themselves that potentially have character and visual amenity effects, there's also the consideration of cumulative amenity effects, so considering the combination of noise and the other amenity-related effects together. So that matter of discretion would cover those issues.
Yes. Is there any policy support or any indication in the zone in terms of the categorization of activities, in terms of, ones that are compatible and non-compatible, that would support restricted discretionary activity status over discretionary activity?
I think policy 2 talks about operational need. And I think in most cases, it would be a site-by-site consideration, but in most cases, waste management facilities are likely to have an operational need. But in looking in the broader planning context, and I appreciate the NPS for infrastructure was enacted after, or came into force after the plan was notified. But the NPS infrastructure does take an approach of enabling these facilities in all environments. So I think there is support for a restricted discretionary activity status in that context. And also just note that a restricted discretionary activity status means that effects can still be well assessed through the consent process, and just is generally used rather than a discretionary activity status where those effects can be well defined.
Yes, I understand your point. Thank you. That was all from me.
Thanks.
Yeah. Here's a couple from me. Your paragraph 38, where you list the potential matters of discretion which could be outlined in the rule. And point B, you've got effects of lighting, noise, dust and odour on the amenity values. Where does visual effects fit into that matrix?
I think visual effects could be added in, but my thinking was that also gets captured by the control on building size that's in the plan as notified.
Yeah.
But it would be a good idea in reflection you could add in visual effects as well.
Yeah.
In that second matter.
Okay, because in my experience, that's some of the problems that these sorts of things have to encounter is what they're going to look like. They can potentially be reasonably utilitarian structures and activities over the range of the site as well, depending on what is actually happening.
Yes, and modern facilities, Sarah might be able to speak to this more than I can, but my understanding is most activities take place indoors. But outside of WM, the plan provisions need to relate to all waste management facilities. So adding in visual effects would capture, for example, a hypothetical future proposal that did incorporate some outdoor storage or something like that.
Yeah. the last question for me is, in terms of integrated planning, a typical resource recovery site, does that trigger regional consents as well?
Yes, it does. So commonly it will trigger regional consents for discharge to air. So that would be fugitive odour and dust. And then potentially a stormwater discharge consent.
Yeah. And normally, particularly in relation to the first one, fugitive odour and dust, are they normally discretionary or restricted discretionary?
Normally discretionary.
Okay, thank you. Thank you both for that. I don't think we have any further questions, and you've been a stayer through the first 3 of the hearings. Presumably you're looking at hearing stream 7 and 8 as well. Would that be true?
Yes, I think the infrastructure hearing stream would be the next one, and then the Benmore Crescent one.
Okay, so it's 6 and 8. All right.
And potentially the natural hazards one. I wasn't too sure where the flooding overlay for Benmore Crescent sits.
Okay, all right. Well, sounds like we'll see you again anyway. But, thank you for your time.
Thank you very much.
Thank you.
Right, next submitter, Brookfield Board and Scouts Aotearoa. And we have Mr. Bell and Mr. Keatley. I'm sure I've come across you before, Mr. Bell, somewhere. I can't think of what it is. Who knows?
I can't be sure either, Commissioner. Just,
Like we have your submission. We don't have any additional material received from you at this point, but presumably you're here to speak to your submission?
yes, we're here to speak to our submission, and I've prepared a small presentation to go along with that.
All right, thank you.
Thank you. Brookfield is quite unique in the Hutt City in terms of that we and Camp Wainui are the only 2 facilities providing outdoor education in the Hutt City. We're somewhat larger than the Camp Wainui, being some 30 hectares bigger, and we have significantly more facilities. So our land area is 255 hectares, which makes us bigger than Zealandia. We border the Greater Wellington Regional Council water catchment. We are designated a wildlife refuge under the Wildlife Act, and as such, I'm, as chair of the board, responsible to the Minister of Conservation for that. And we sit on the ecological flight path from the Orongoronga and Wainuiomata River catchments to the Western Hutt Hills, across Stokes Valley and across the Manor Park Golf Course. We were established by a bequest back in 1958, and we've been the custodians of the property since then. We have accommodation for 130 people indoors, and we can camp over 1,000, evidenced by the event that we had earlier in the year, which had 1,300 attendees. Our usage is about 30% or a third for use by scouting, and we have other significant clients in terms of schools, community groups, Wellington Folk Festival. As a business, we attract a lot of schools from out of region, out of the city. We attract, like the Wellington Folk Festivals, bringing a lot of people into Hutt City. We are totally volunteer run, and we happen to be one of the largest private predator-free projects in the city. If you look on the screen, we're just approaching our 4,000th rat in the last few years in terms of extermination. We've got something like 580 traps in place. Our current zoning is general rural, which to us is a challenge. We submitted in our submission on 5 points. We objected to the application of the rural life zone to the northern end of Moores Valley Road, or particularly to the definition of all of that area. We objected to the proposed rural lifestyle zone minimum lot size of 1 hectare, and I'll show you what that means shortly. We commented and objected to the outstanding natural features and landscape overlays being applied to our property, and I'll come to that in a minute. We objected to the slope overlay being applied to our property, and we also requested the changing or consideration of changing the zoning for Brookfield as a special purpose zone, and we asked to talk to the planners about that, but we've had no approach from any planner through this process. If I could start by looking at the outstanding natural features and landscape. I think we stated our objections much through ignorance and concern with the special natural area designation at the time. So potentially our concerns are mitigated by the 7 identified features and landscapes we see in the district plan, which we understand to be from Turakarai Head through Bering down to the Rimataka Range. However, that said, we cannot find any definition of the Rimataka Range in the district plan. It might be there, but we're not aware. As we border the Greater Wellington Regional Council water catchment, which could be considered part of the Rimataka Range, we do seek some clarity that we would not be covered by this reference. So,
Can I just stop you there? Outstanding natural features and landscapes are no longer part of the proposed district plan. You'll be familiar that there was a plan stop process and
Understood.
the council decided which parts of the plan they will proceed with. And this was one of those outstanding natural features and landscape, which was one of those, but the operative district plan may well apply still.
yeah, okay. That's reassuring. In regard to the application of rural lifestyle zone designation at the top of Moores Valley, and coupled with that, the rural lifestyle zone minimum lot, I guess our submission is based around Scouts Aotearoa's serious concern about protecting the wilderness aspect of outdoor education that we provide. We have an example with the Scouts equivalent Auckland facility known as Motumoana, which started life on the shores of Blockhouse Bay, remote from any urban development. It is now surrounded by housing and is no longer a wilderness camp. Furthermore, the land value has increased, and with that, the rates, issues with neighbours, noise, etc. And it's the Brookfield Board's hope that through this process we might be able to protect the property to ensure that we maintain some level of wilderness activity. We're concerned particularly about the block at 100 Brookfield Lane, which is fully zoned rural lifestyle. I've marked it up in red here on the slide, and is obviously blue in terms of the plan. Particularly, we're concerned about the lot sizes that might eventuate. This was, and potentially still could be, but subject to, I suspect, the resource consent is passed. This was the development of Brookfield Lane, and that's the alignment as it goes in terms of running south-north, but this is the page that the survey plan. Lots 1 to 10 on that plan have been developed, but the further lots are stalled. We've endeavoured to reach out to the owners of this property on numerous occasions, but have not had an ability to engage with them. If you look at the lot sizes on those slides, they vary from 2 to 3 up to 5, 6, 7 hectares. If you were to subdivide one of those 5, 6, 7 hectare lots into 1 hectare lots, you can see the intensity of subdivision that would occur in the neighbouring valley. Of particular concern to us is not to have subdivision of property that would have dwellings overlooking the Brookfield Valley. If the red line there on that slide is the ridge line, and anything built along that ridge or even approaching the ridge on the other side, on the upper side of that, would look down at Brookfield or be seen from Brookfield, and hence we would lose any wilderness area or feel for what we're providing. We're not objecting to that valley being subdivided, but we would like the council's support in trying to protect not having built area to the south or to the bottom of that red line, potentially the green line, which would be a margin set down from the ridge line. The implication of that is that in this photograph, that upper red visual line, at that point you can see Wellington Harbour. Right? The height of the property is such that we're looking over the hills right into Wellington Harbour and into Wellington itself. But if we've got housing and dwellings along the ridge line at that point within the green, then that's going to be detrimental to experience a wilderness opportunity. We can presently take young people on a 3 to 4 hour hike and return them to a cabin in the middle of the bush where they don't know where they are, and they've got a tramping experience on a private property, which is a great training facility. So there's the green line that we would be quite keen to sort of protect within. It's also our understanding that this level of intensification that could happen if the district plan goes ahead with dropping to 1 hectare lots will mean an intensification of other things that are required, such as public amenities like sewer pipes along Moores Valley Road. Though we suspect the cost of that will probably mean a delay to any of this happening in the future, but it could happen. Put into the context of sewer pipes were put up Moores Valley Road, and we were required as a property to connect to the public sewer due to this intensification, we would incur a cost at the present point in time, costing, which has been done quite, it's not just a guesstimate, it's been costed, would cost us between $400,000 and $450,000. That represents 20 years of our surplus income per year for the next 20 years. So that's quite significant. Moving to slope assessment, the designation across our property seems reasonably arbitrary. We're not quite sure why it would take the alignment it does. We are never likely to develop up in the upper reaches of our property, other than perhaps put another tramping hut in if we could. And so our approach would be to remove the designation of the slope assessment across our property because it's just inconsistent at the moment. And the last aspect is our request of exploring whether we could be zoned as a special purpose zone. Under the, going back to prior to the merger of the different boroughs within the Hutt City, Wainuiomata Council, for instance, under their plan, both the Camp Wainui and Brookfield were zoned specially for outdoor education centres as special purpose zones. This was to recognise the unique nature of what we do on the property and also to provide some flexibility as to how we can manage it well. If you look at the general rural zone, it is limiting in terms of how we would move forward, and it's not applicable to our use. As an example, contrary to the current rules, we are a non-rural business. We charge a fee for recreation activities on site. We have 2 managers living on site at this point in time, which would be contrary to the district plan. Obviously, we've got existing use rights, and it is what it is, but we operate 24 hours a day, 7 days a week. Just in terms of height, we have an abseiling tower that exceeds the maximum height of 11 metres by probably another 7 metres. It's the highest freestanding abseiling tower in the city, if not the southern part of the North Island. So those are just some of the unique non-compliant things that we have at the moment. We have as I've already said, accommodation for 130 people and camping for up to 1,000. Yet the district plan permits us on our property to only have 10 guests. All right, 10. We managed to put a tramping hut into the second part of our property because we had a separate title and it's limited to 10 people. That's not very, no, we would have liked to put a bigger tramping hut in without going for a resource consent, but it wasn't possible. We put one for 10. The gross floor area of all our buildings and structures is meant to be 800 square metres. Presently, we have 1,500 square metres. So if we want to upgrade our ablution block, we will be non-complying with the district plan, and that will necessitate a resource consent, which is actually valuable money to us in terms of operating a volunteer business. So those are the reasons we would like to consider the opportunity to be a special purpose zone, because we think it would be way more appropriate for the way we would operate as a community facility within the Hutt City. Steve, do you want to add anything to that? Or you right? Thank you for the opportunity to be heard.
Well, thank you. I'll just check on some questions from my colleagues.
Sorry?
Thank you. I just had a couple of background questions, really. So do you operate under existing use rights now? You don't have a consent to operate as such. You operate under existing?
We operate under existing use rights. The structures that have been built in more recent times have been all approved by council. We have a camping ground licence, right, which is issued by Hutt Council. But if we want to improve our facilities, that's going to be a challenge.
And so you also said you're a volunteer business, but one of your slides said that you charge for usage, recreational usage or something.
Yes, so scout groups pay a discounted rate. Community groups, church groups, like all hire our facilities. We can often, because the way we've set it up, we can have 5 or 6 different groups there staying for a weekend. Schools come and pay. We have 2 schools a week staying there at different times. They charge for that.
Yeah.
We turn over, last year, financial year, which was our best year, we turned over $200,000.
Right.
But our costs are proportionate to that as well. So, but our site managers are volunteers. They work full-time. They live on the property. But they work full-time doing other occupational jobs. Yeah.
Yeah, no, I understand. Thank you. So I'm assuming we'll get a copy of the slides that you were showing us. We didn't have a copy of those previously, so that would be helpful. And I just want to clarify that there's a portion of lifestyle zone that you want rezoned to general rural, and the rest you're looking at some sort of special purpose zone. Is that?
We would request being able to discuss creating a special purpose zone for Brookfield.
Yeah.
And regarding the neighbouring rural lifestyle zone, there is a portion of that could either be rezoned, or alternatively there's a building restriction put on the portion along the ridge and for a distance below the ridge, so that if anyone's buying those properties, they would have to build down below the ridge line. I mean, whatever mechanism is appropriate is something we need to discuss. Yeah.
Sure. Are there any other sort of wider issues that you're potentially aware of, like, for example, like traffic issues or things like that that would stem from your activities that may need to be looked at further?
Well, with the existing Moores Valley Road, we didn't have any. I mean, we ran an event with 1,300 people at New Year, which doesn't happen that often, but it happens from time to time. There weren't any significant traffic issues with that. actually, the participants of that event parked down at Homedale at the beginning of the valley, and we provided vans to shift people from, or the organisers provided vans to shift people from Homedale to our site. Similarly, with the Wellington Folk Festival, which often draws about 800 people, that's been going for a number of years, and the traffic issues have been handled well over that time. So I don't see any issues of that nature. Yeah.
Okay. Thank you. That was all I had.
Yes.
Just a follow-up question. I think it's, just trying to work out which slide, it might be the 10th or 11th of your slides. You've got the red property, which I assume is 100 Moores Valley Road. Oh, sorry. And the yellow outline is Brookfield property. Is that piece in
That one there?
between?
That one there?
Sorry.
The piece in between, yes,
That's what you're talking about, that transition zone of a,
the rural, yes, just bring the slide back up if we can. Here we go. The piece, the rural lifestyle zone connects to us at the top there, right? In between that property and our property is a farm, right? The slip of land in between is a farm, right? The farmer has no intention of any development, and we don't see, and it's also zoned general rural, and so we don't see development of that as an issue, right? But it's the section between the farm and the top of the ridge that's the issue, right?
and that's denoted by the green line on there? Okay.
The green line, if I go back a slide. So the green line represents the green dashed line there, which in my mind is a notional line. It could be 5-10 metres below the ridge line, so that anyone who's building would not be seen over the ridge. The ridge line is the red line. So anything in the rural lifestyle zone is the brownie bit there below the red line, right?
Okay,
and that's
no.
where people could build at the moment at 1 hectare density.
Okay, thank you for clarifying.
Just having a look at this subdivision plan, you are concerned about proposed lot 41, and then the backs of those lots from 43 through to 54.
Yes, yes.
Am I right to assume that they're pretty steep parts of those sites anyway?
Yes, they are pretty steep, though that 41 has been given a right-of-way access up to it. If you can see,
From where? From in between
right-
number 3 and 7, is it?
the right-of-way access is coming in through from 45, across 45, 47, and across 43.
Oh, yes, I see.
That's the right-of-way access, and once you get there, you're not that far below the ridge.
Okay. And this has never been lodged or approved. Have you been in discussion with?
Well, this has been, the first stage of this has been built,
Oh, okay.
right?
So it could proceed on the basis of this.
Lots one, no, I believe, I tabled this to show what was potentially going to happen.
Yeah.
And what started to happen in terms of lots 1 to 10. It's fair to say that this is expired now because of time, and but it's indicative of what could happen up that valley.
Yeah.
And given that these lots are significantly bigger, and the proposal to come down to 1 hectare will significantly increase the density of that if it was to go ahead.
It's a matter of quite a few ifs and buts, though, isn't it?
Yes, true.
In terms of,
Yeah.
obviously, if you go down to lower lot sizes, then there's a expectation that there'll be some sort of servicing? Presumably these is all based on septic tank, waste disposal, no reticulated water supply, so it's all rainwater.
True.
And so there are some limitations to that. The smaller the lot sizes, the greater there is for much more attention to that sort of detail.
I guess as an owner, not in Hutt City, but elsewhere, of a 1 hectare property which is fully self-contained with sewerage and water, it's quite feasible to do 1 hectare though.
Yeah, but it's depending on the ground conditions. Yeah, I accept what you're saying. You haven't had any discussions with the owner of this property, like, transferal of lot 41, for example, or any of those sorts of activities been having?
The owner of the neighbouring farm would very much like to purchase lot 41, has expressed that to me. I have reached out on numerous occasions to try to make contact with the owners of that property, 100 Brookfield Lane, and have been unable to do so.
Okay.
I have approached family members and asked the trustees of the property to give me a ring or make contact, but to no avail. Our ultimate concern here is we'll do what it needs to protect the wilderness nature of the property. There's another property at the northern end of Brookfield, which is actually currently landlocked. It's known as 562N Moores Valley Road, and we've got discussions going with that neighbour at the present.
Okay.
So,
Oh, that's clear. It's been probably 20-something years ago, since I went to the scout camp and accompanying my son years ago, but there was a lot of camping activity, and there's a collection of ablution blocks and so forth there as well. How do you in terms of waste management, how do you deal with 1,300 people there?
We, with 1,300 people, we bring in, we require any when we're not running the event, but we require any body running an event like that to bring in alternative temporary ablution facilities, which are pumped out every day. I mean, we ourselves, for our normal operation, could have up to 200 to 300 people there at a weekend easily, and our ablution facilities and septic systems handle that well. We've got actually, I think, 9 septic tanks on the property, which are regularly cleaned. We had one of our bigger clients at the moment is the Victoria University of Wellington, and their ecology students who come in for 2 weeks or so. They've just done some testing of the water right through our property and up the valley, and it's actually no evidence of any issues. So
okay. So in terms of nutting out your relief or what you want out of this particular process, you'd like this property here to be rezoned just general rural?
Well, we'd like a section of it to be rezoned so that
it's not quite north-south, is it? But the eastern side.
The eastern side of it, yes.
Okay. And you'd like a special purpose zone to reflect the activities on the site?
Yes.
Have you gone to the stage of actually putting it in planner speak, what that might be?
No, we have not. I had done that previously under the previous council arrangement, but not under Hutt City. But that's something we could do and submit. And
in terms, you mentioned you had existing use rights, and you've got general rural zoning. So the impediments to you blossoming, doing all that you want with that particular site, are what?
Well, if we wanted to put a further tramping hut, one of our goals is to make use of the full property, and our recent hut that we put in was for junior scouts, if you like, but for older youth, I give them a 5 to 6 hour tramping experience, because that's the length of time it would take to get to the end of the property hiking. If we put a tramping hut in there, even if it's 15, 20 beds, at the moment, that would be prohibited and would need a resource consent, obviously.
Well, it would need a resource consent.
Yeah,
It wouldn't
yeah.
be prohibited.
No, but it would be.
But you could presumably make your case for it.
Yeah.
And
True,
continue.
true, but I guess it's the convenience of being able to use, when we've shown we're custodians of property, we've been looking after it for some 60+ years, and we'd like that ability to be able to keep doing that without having to sort of go through the added cost of doing resource consent as the like.
Okay, that's understood. Thank you for that, and thank you both for your time. It's much appreciated.
Thank you.
Go back to the offices now and take up where we left off with Mr. Bellamy and, sorry, just having, Mr. Horrell just having a slight senior moment there. So, Mr. Bellamy, do you want to go first with the remainder of your Section 42A report and your rebuttal? Is that going to be the most efficient way of doing it?
I might actually, if the panel was happy with that, if I start, I can
Yeah.
provide a bit more of an overview of the.
We're in your
topic.
hands.
Okay. In that case, I have prepared a hearing statement similar to what Ms. Pascal had taken us through. So I'll just take us through that if that suits.
Thank you, Mr. Horrell.
My name is Charles Horrell. I'm a principal planner at Boffin Miscall Limited. I've prepared the statement of evidence dated 15 June 2026 in relation to the rural topic on behalf of Hutt City Council. I understand that my evidence has been taken as read. I've been engaged by Hutt City Council following the circulation of the Section 42A report prepared by Mr. Sean Bellamy. Since that time, I've worked closely with Mr. Bellamy in preparing for this hearing, reviewing and responding to evidence filed by submitters. Responsibility for the rural zones topic has been allocated between us. Mr. Bellamy continues to address rezoning requests and quarrying related matters, and I just might point out for the quarrying related matters that does relate somewhat to a conflict that I've addressed in my statement of evidence. While I will be managing all other matters related to the rural zones and associated definitions. To begin, I'd like to acknowledge the work that Mr. Bellamy has undertaken in preparing the Section 42A report and the considerable input from submitters and their experts throughout the process. Having reviewed the evidence filed by submitters, I note the broad support for many aspects of the rural zones framework, with the remaining areas of disagreement generally related to the extent of development opportunities that should be provided for within the general rural zone and rural lifestyle zone. To assist the panel, I'll briefly provide an overview of the rural zone chapters and matters raised by submitters before the focus of my evidence. So the rural zones establish a planning framework for Lower Hutt's rural environments. They comprise of two zones, the general rural zone and the rural lifestyle zone. In addition, the quarry zone protection overlay applies over parts of the rural zones, and the highly productive land overlay was notified with the rural zones, but I note that's since been withdrawn. The chapters seek to address a number of key issues within the district's rural areas, including maintaining the rural character and amenity values, providing for rural activities and activities that require rural location, managing reverse sensitivity, and recognising infrastructure constraints within the rural environment. Hutt City, Lower Hutt's rural areas are characterised by a mix of primary production, forestry, rural lifestyle living and open space values, with generally low levels of built development, limited with limited access to reticulated infrastructure. The rural zones chapter distinguishes between the general rural zone, which is primarily focused on rural production activities, generally seeks to maintain allotments of at least 15 hectares, whereas the rural lifestyle zone provides for a greater degree of rural residential living with allotments of at least 1 hectare. Overall, the chapters seek to strike a balance between enabling the ongoing development of rural land while protecting the character, function and productive capacity of those environments. For context, I've given in Appendix 1 and Appendix A the spatial extent of both rural zones. Appendix B gives a distribution of the size of properties in those zones. I guess the context to that is how the number of properties we're dealing with here isn't a large number, and they're generally quite small properties. We're not looking at large farming operations that you might see in a typical general rural zone. They are typically quite small. And Appendix C gives a high-level framework diagram illustrating the key objectives, policies, rules of the rural chapters and how they operate. Was there any questions on those appendices before I move on?
None from me, other than to acknowledge the presence of them. They're really useful as a roadmap for working way through. In preparing those, did you identify any roadblocks or any orphan provisions?
No, I didn't. I guess I note, Mr. McMahon, you do prefer a wiring diagram, which is partly why I had included that, but I did prepare it for my own benefit, just to understand how the
it's a useful exercise, regardless of whether I request it or not.
That's right, but no, I can confirm that there's a clear articulation from the strategic direction right through to the rules and standards.
Yes, well, there's 2 big ticks in my margin here on my iPad, so thank you for that. Can I, just while I've interrupted you though, can I just go back to the overview in terms of the highly productive land overlay that was notified and has been since withdrawn as part of Plan Stop. So that, well, first question, is there any land use category 1, 2 or 3 land in the district?
There is, I'll have a go and I can pass it to Mr. Bellamy to provide further context, but there is a largely land use 3 land throughout the, and that's largely through the Wainui-Mata Valley.
Yes.
As you've noted, during the Plan Stop, that those aspects of the plan were removed. Picking up on your question earlier, as to the degree to which the MPS highly productive land continues to apply. Given it's been withdrawn from those parts, we won't be considering it any further as it relates to the land use rules. I guess the one residual matter where we would consider it is for any rezoning requests over highly productive land, and that would be LUC 1, 2 or 3. There was a change to the MPS HBL to allow for resource consents not to consider over LUC 3. That doesn't, though, change the definition of highly productive land as it relates to rezoning.
Plan making. Yes. And essentially the MPS HPL, in terms of its objectives, policies and standards, become a deemed provisions in the plan.
Could you repeat that, sorry?
The provisions of the MPS HPL, in terms of the objectives that are in that, the policies that are in there, and the standards become deemed provisions in the plan.
They do, yes.
Okay. So two functions: 1 to assist in rezoning request, and 2 as a consideration for resource consents that trigger LUC 3 land in this case. That is highly productive by definition until the regional council update their planning maps.
That's right.
Thank you.
Did you have anything to add there, Mr. Bellamy?
I'll just add one thing. There is another change to the NPSH PL that affects the definition of highly productive land, but it's pretty small. It's if and I'm not sure on the exact, the definition is quite narrow. It's when land is, a resource consent is granted for land that is not for rural residential use. It can remove land from that definition, so just to be aware that that's a slight variation to it.
Okay, so moving into the submissions. So there was 153 submission points and 41 further submissions on the rural zones topic. The principal matters raised in those submissions included the purpose and character of the general rural zone and rural lifestyle zone, the opportunities for residential development in rural areas, the extent and operation of the highly productive land overlay, protection of existing quarrying activities through the quarry zone protection overlay, activity statuses and development standards applying to rural activities, and several site-specific zoning requests. Many of those submissions sought more enabling framework for residential development, rural-based activities and other activities. Conversely, other submitters sought stronger protection of rural character, productive land resources and ongoing operation of existing activities such as the quarrying activities. So we have touched on the withdrawal there, so we'll just quickly move over that, but just to note, in addition to the highly productive land matters, also the natural environment matters were removed, which did have quite an overlap in the rural zone. So my evidence, in preparing my evidence, I've reviewed the relevant submissions, further submissions, Section 42A report, and the evidence filed by submitters. As set out in Section 4 of my evidence, I generally support and adopt the recommendations contained in the Section 42A report in relation to the matters allocated to me. The focus of my evidence is therefore responding to submitted evidence and identifying where further refinement to recommended provisions are warranted. In general terms, I continue to support the overall direction of the Rural Zones chapters and consider that it provides an appropriate framework for managing rural land use and development in Lower Hutt. Principal matters where I've recommended further amendments or further clarification to the Section 42A report relate to one, refinements to the recommended amendments to policy GRUS P3 relating to potentially incompatible activities and reverse sensitivity effects, and two, a modified rule framework for intensive indoor and intensive outdoor primary production under GRUS R14. Other than those matters, I support the recommendations contained in the Section 42A report and associated recommended provisions. I've reviewed the tabled letter from Greater Wellington Regional Council. I note the Regional Council supports the recommendations contained in the Section 42A report as they relate to the submission points for the rural zone topic. There are no additional statements or legal submissions that have been filed since the circulation of my evidence that are relevant to the submission points allocated to me, and I am happy to answer any questions from the hearing panel.
Thank you. Got a summary statement from Mr. Bellamy as well. So should we, it's a little bit odd. We've got one 42A report and we've got two rebuttals, okay? So it's just a matter of how we deal with that. What do you think next? Well, to some extent he does. Well, Mr. Bellamy, you had a summary statement. Do you want to read that through? And then while you do that, we'll work out how we'll approach the rest of it, whether we do the page turn as we did with residential or deal with it by exception.
Sure. My name is Sean Bellamy. I'm an intermediate planner for Hutt City Council's District Plan Review Team. I prepared the Section 42A report and the rebuttal evidence dated 15th of June 2026 in relation to some of the rural zone topics. I understand my evidence is taken as read. As set out in Mr. Horrell's hearing statement, responsibility for the rural zones topic has been allocated between us. I continue to address submission points on the rural zones topic that relate to rezoning requests and quarrying activities, with Mr. Horrell addressing all other matters. Since Mr. Horrell was engaged, I've worked closely with him in preparing for this hearing and in reviewing and responding to the evidence filed by submitters. Mr. Horrell has already provided a general overview of the rural zones topic, including quarrying activities through his statement, but to assist the panel for the matters allocated to me, I will provide a brief overview of the rural zoning and the rezoning requests before discussing my evidence. As noted in Mr. Horrell's opening statement, the two rural zones, the general rural zone and the rural lifestyle zone. General rural zone largely reflects the spatial extent of the general rural activity area in the operative district plan, excluding the areas of Department of Conservation, land and regional parks, which are now zoned natural open space. The rural lifestyle zone largely reflects the rural residential activity area, with some modifications to zoning boundaries, including at the northern extent of Wainuiomata. Although submissions on the proposed district plan, through submissions on the proposed district plan, several submitters have sought site-specific rezoning of land currently proposed to be zoned general rural zone or rural lifestyle zone. These requests include rezoning land from general rural zone to rural lifestyle zone to general rural zone, and rural lifestyle zone to medium density residential zone. My evidence in the Section 42A report, I assessed the rezoning requests and submission points relating to quarrying activities from the rural zone topic. My rebuttal evidence provides further consideration of the evidence filed by submitters on those matters and whether any refinements to the recommended provisions are warranted. My rebuttal evidence contains an error. It incorrectly lists Karen Rosser as the representing Waste Management New Zealand Limited on page 2 of the report. This should be Environ NZ Services Limited. In considering the relevant rezoning requests, I have relied on evidence provided by Luke Brenner and Matt Atkinson, talked about that before. As relates to quarrying activities, I continue to consider the recommended quarrying provisions provide an adequate framework for managing quarrying activities within the rural zones and do not warrant any substantive change. I acknowledge and have read the legal submissions filed on behalf of Winston Aggregates. In particular, I note that Winston's concern that its further submission point, FS 33.9, was misconstrued and did not seek the inclusion of the quarry zone within the definition of urban environment or rural environment. Having considered the submissions further, I agree that the quarry zone should not be listed in the definition of urban environment. While I note that Winston's preference that the quarry zone is not expressly included within either the urban or rural environment definitions, I consider this would create an inconsistency given all the other zones are referenced within these definitions. Accordingly, I recommend that definition of rural environment be amended to include the quarry zone. I recommend changes to these provisions in Appendix A. In relation to rezoning requests, I consider that there is a lack of evidence to support the majority of the rezoning requests sought. I've already talked about the specific site at 104 Upper Fitzherbert Road, so I won't talk to that. I'm happy to answer any questions the hearing panel may have in relation to my evidence. And obviously Mr. Brenner and Mr. Atkinson have all already answered questions.
Thank you, Mr. Bellamy. Perhaps we'll deal with your part of the your rebuttal first and go through this by exception. So I'll just go right to the top. Again, same format as we did with the 42A report this morning. Introduction, supporting evidence, response to submitted evidence and statements. Issue 1, quarrying in the rural zone. paragraph 5.9, the whole issue of quarrying being, is it rural, but, or is it, potentially compatible with rural activities? Isn't it a fact that they are what they are? They, regardless of whether they're in a rural environment or anywhere, they have certain attributes to do with quarrying that mean that some sort of recognition needs to be made of them.
I think in writing this, I was giving consideration, I guess, to farm quarries, the types of things that occur within a farm, and I guess reverse sensitivity. I see reverse sensitivity is slightly different for a quarry that's supporting rural activities as opposed to a general broader, and that was the intent of the inclusion. But you are right in that, I agree with you that quarrying is what quarrying is, and that they produce the same general effects. The difference, I guess, would be scale and reverse sensitivity.
Yes, okay, thank you. I'm at para 512. Before that. Then we're into issue 2, which we've dealt with. Issue 3, clean fill and quarrying activities. Now, we heard from Waste Management this morning, or just before, who seem to have an acceptance of your recommendation. Have you got any views on that?
I think that, or my view is that, I think they've raised some points. I guess the question is where, if it's to be managed as a restricted discretionary with a limit, and this is probably more Mr. Horrell than myself in terms of the way we've split this, would be that it's an appropriate level, what size, and are all the things that need to be considered included, like reverse sensitivity potentially, and how would hours of operation be picked up, those kind of things. So in principle, it sounds like it may well be something that could be done, but my concerns would be those particular issues. Anything to add, Charles? Sorry, I might have misinterpreted your question. Are we talking about in terms of the provisions at the end of GRUS P2?
For starters, they had originally wanted recognition of existing quarrying activities, which they seem to have resolved away from.
Yeah, I guess my thoughts on it are that the way the provision is written provides for potentially compatible activities. It doesn't define them as compatible. And I think that with both those two types of activities, there is potential for them to not be compatible. And that's an approach, I think, which has been elsewhere in the plan as well. So it's not saying they are compatible, it's saying they can be, and the inclusion of, for instance, the inclusion of the rural environment, or the comment about quarries is for that purpose. So I still would be hesitant about saying it is compatible in case due to scale and size. if that makes sense. That's clear.
Thank you. Any questions of Mr. Bellamy? Okay, well, we'll move to Mr. Horrell. Thank you for that, Mr. Bellamy. And thank you for all your work you've been putting in as well. Right, found the right document. Mr. Horrell, as rebuttal. Okay, I'm actually at 5:14 before I've got a question. Right, at your 5:14, you say, for completeness, I continue to support Mr. Bellamy's recommendation to not include an additional rule to require setbacks from intensive production activities to manage reverse sensitivity. I'm aware that other plans do have some sort of setback from your pig farm or, you know, intensive chicken farm from the boundaries from where the intensive activity can actually establish. Just a little bit unsure about why you don't think it would be necessary or desirable in this context. And this is also recognising that I don't think there's anything in Hutt City at all which could be termed intensive primary production. I could be wrong, but
That's right. In fact, that's part of the reason I haven't gone there with a reverse sensitivity clause, is there doesn't appear to be an actual issue or an observed issue in the Hutt City. Looking at the consent records, there hasn't been any indoor or outdoor primary production granted in the past 10 years. The other side to it is the restriction it may cause, and going back to that map of the property distributions, it would be quite stringent to have a standard setback.
Because you haven't got enough big sites.
That's right. So
Okay.
that was the main reason for not including it, but I do acknowledge that other plans do typically have a setback.
Particularly from piggery operations. Odour normally being the primary issue. Okay. Any other, well, can I just say, has anybody got any other questions, Mr. Horrell?
Just a clarification on your paragraph 513. It's just a typo. It's just, I pick those things up. I just think under the description of the rule, or heading of the rule, activity status restricted discretionary, I think that should be number 1 rather than number 2.
Yes, that's correct. It's a typo.
Yeah, it just means that down the bottom where compliance is not achieved with 0.1 rather than 0.2.
Yes.
Yeah, thank you.
Mr. Horrell, my question relates to your rebuttal evidence in relation to Ms. Goodwin's statement, and it starts page 9 of your rebuttal. You would have heard Ms. Goodwin this morning and the questions I put to her about the different options for dealing with waste management facilities in terms of their activity status. And I outlined 3 options. The notified one, which is discretionary activity, her preferred relief, which is restricted discretionary with some additional matters of discretion, which seemed to be added to during the course of the questioning. And then the third option was a sort of a split approach dealing with graded threshold. There's a number of questions I could ask you on that, but based on what you heard from Ms. Goodwin, is that created a basis that you think that there might be some utility and some further discussion with her on that, or are you fairly firm in your view about that? I just want to give you the opportunity to comment, given she'd spent a little bit of time, she said spent quite a bit of time thinking about it. She wasn't completely dismissing the threshold approach, she just said it would need to have some careful thought, and on that basis her preference was to stick with RDA, but with bolstered matters of discretion for a non-graded approach, if you like. Any immediate responses to her evidence and the question I just put to you about utility for further discussion?
Yes, so I suppose my position remains that a graded framework would be preferable, where small scale can continue to be captured in the RDA, where a discretionary for anything else. Noting her comments around how we could frame that scale, I do generally agree that there could be a way of doing that. She did make the point of that the rural zone already has, say, cumulative ground floor area requirements. My preference would be that is elevated into the rule itself, noting that those ground floor area limits apply to buildings and standards generally, not specifically, say, the land use. It may also be that the ground floor area refers more to the operation as opposed to just the buildings and structures, but I do think that would be an effective way of managing scale. In addition, it may also be setbacks, would be another form. You did also put the question to Ms. Goodwin on does the policy framework appropriately anticipate that? I would generally agree that it does, and that it's an operational need to be located. I may, though, recommend if the panel was of an opinion to provide for an RDA, that small-scale waste management activities is listed as a potentially compatible activity.
Yes.
And that would just be consistent with how the remainder of those activities are.
That would be a consequential amendment.
That's right.
Yeah. I'm just hearing that there might be some merit in further discussions.
I would be open to that.
Yes. Well, I was conscious of one of the answers from Ms. Goodwin, and she said she didn't want to respond to on behalf of all waste management facilities, but she said that her clients' ones were predominantly indoors and well run. That in itself could be a simple delineation, indoor and outdoor RDA, DA. I mean, it's not my role to put words in your mouth, but it seems that there's a number of ways that could be sliced and diced.
Yes, I think it could be. In fact, we could discuss it further, but it could even be a disjunctive for indoor and then a scale for outdoor.
Sure.
But I'd be happy to work further with Ms. Goodwin on that if directed.
Yes, well, we'll have a think about that anyway in terms of putting some questions in our follow-up minute at the end of the hearing. Yeah, I also had some questions around if it was an RDA, how it was going to be split, what's big, what's the cut-off in between the two. Isn't it just a line of least resistance just to go for fully discretionary, and people can make your merits based on it as being one option, with so many variables potentially in play if it was an RDA. But we'll pose some questions on that anyway. Okay. More questions, Mr. Horrell?
asked and answered.
Okay. Do we want to round back to the section 42A report to see if there is anything? If people can just quickly go through their questions. Well, Mr. Bellamy, but if it is now in Mr. Horrell's wheelhouse, then he.
We had that comment earlier about integration.
Between regional consents.
What got taken out.
Sorry, we were just having a wee discussion
Yeah.
about something we dealt with this morning, which was in terms of the right of reply, an indication about which parts of the ODP remain in play in the rural zone and in the residential zone for that matter as well. How big a job is that? Because it will be quite good to actually have that in front of us in terms of integration. And we put that in our minute 2 in relation to hearing stream 2.
I don't know if it's a question, it's more like maybe a standing matter to, have attention to as we work through all of these topics. Yeah, but if you have a comment, go ahead.
I could make just a small kind of explanation, I guess, is that these reports were drafted at the time of the second hearing. So I think they came out the day before, the Friday before, or the morning of the hearing. So we didn't have the minute at that point, I don't think.
Yeah, and that was expressed in the minute in relation to hearing stream 2, and I think we're only looking from hearing stream 5 onwards, knowing that the officers' reports were, basically we had one hearing, and just before that, the officers' report for the next one is out. So we did recognise that. We might have already covered this. In terms of paragraph 240 of the section 42A report, concerning GRUS P3, potentially incompatible activities. And you're recommending 2 new clauses under 1. One relates to significant reverse sensitivity, but the second one would not be significantly incompatible with the use of the zone for future primary production activities due to being a sensitive activity in relation to primary production activities. Is there any way of just making that a lot clearer with what you mean? It's just, I've read it 2 or 3 times and I don't exactly know what you mean.
Yes, that was one of the matters that I further refined.
Sorry. Apologies, Mr. Horrell. It was too.
But I can just quickly explain what I've recommended. So my review was that clause A of that policy, maintain or enhance the character and amenity values of the surrounding area, would already account for that incompatibility. And how I've interpreted that is that objectives 01 to 04 give that clear indication of what is the character and amenity of the rural zone and what activities are anticipated. So any circumstances of incompatibility or significant incompatibility would be managed appropriately through A. So I've suggested deletion of the additional clause E.
I've got nothing further that we haven't already discussed.
Just one from me. Paragraph 49, you refer to the updated HBA study and that it's still under progress, but it's expected to be available for the close of the hearings. Any update on that? Any update, Nathan, on the HBA and when it might come online?
I understand that the actual final HBA document is still a couple of months away. It has been a bit delayed. There can be the potential for us to get headline numbers out of the HBA in advance of the actual report, which may be of assistance. But I suspect that even those headline numbers will still be more than a month away before we'd be able to provide them to the panel.
Yeah, to be honest, it's probably more of an issue for the previous hearing stream.
Yep.
Yeah. And any deliberations on that. Yeah. Okay, thank you.
Anything further on the 42A? Yeah. I don't have anything further either, so we'll adjourn for the day. Thank you all for your time. It's been useful to us to have that discussion with you. Got a lot of submitters tomorrow. I am a little bit concerned whether we're going to actually squeeze them all. The morning seems very busy, but we'll see how we go. It may be that we have to get on the phone to some of those submitters to ask them to come along a little later, but I think we'll see how we're going to program about the middle of the morning and make a call then. Okay, all right, we'll adjourn for now. Thank you very much.